That's scary. Good evening, ladies and gentlemen. We'd like to welcome you to our meeting this afternoon. Before we get started, if you will, for me, if you will turn off anything that makes a noise, that beeps or buzzes or rings or whatever, so that we can all concentrate on what we're here to concentrate on. And also it sometimes disrupts us as well as the neighbor sitting with you. So if this time, if you will turn off all your devices, I certainly would appreciate it. At this time, if you will stand with me, please, we will have the pledge and the invocation. Commissioner Jones.
Father God, we're just so grateful tonight, Lord. We thank you, Lord, that we're on the eve of such a momentous time, Father God, the election tomorrow. All we can say, Lord, is we appeal to heaven. We appeal to heaven because this nation was formed on godly principles, and we know that you can turn it around. We know that we're sitting right now in a pivotal time, oh God, and we ask, Lord, that your grace is sufficient and that you'll come through with flying colors in whatever the decision is. Father God, we just thank you for this commission. We thank you, Lord, that you're giving us wisdom and guidance in every decision. Lord, you're bringing peace to every controversial situation, even concerning the customary use. Lord, there's got to be a reason. There's got to be a solution that we can come to, that we will all get along as a community. And we ask all these things in Jesus' name.
Amen. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. For Commissioner Meadows and Commissioner Enfield to join me down here, please. Yes, you have to. I would like to say on behalf of your fellow board members, I got to look at both of you. On behalf of your fellow board members, our employees, and the great people of this county, I want to thank you so much for your leadership in the years that you've served the commission, okay? Each of you have brought your time and your talents and your knowledge to make Walton County a better place. And for that, I thank you, and I know the people in this room also thank you. You've touched everybody's life for the better, and especially mine. You have made my job better because I've known y'all, and I've looked to both of you for wisdom. I say when I look at the 5 people sitting up there, we all bring something different to the board, which is good that there are 5 of us. And each of you have brought wisdom that has made me a better commissioner. And I want to thank you for that. And I want to ask that may God bless you. And from here on out that you just have the best time of your life. And always come back and visit with us. Okay? So on behalf of the board, I would like to give each one of you a plaque saying thank you and recognition for your honorable service as a commissioner in Walton County. Thank you. And you have 10 minutes each, so you know, go ahead. And also, before we get started, I want to remind everybody that this is Veterans Day this week. So if we have any veterans in the audience, we would like to say thank you for your service to our country. Yeah. Next, let us consider Any additions or deletions to the agenda? Mr. Jones?
Thank you, Madam Chair. Commissioners, the only change is we would request to remove items 10 and 11 from the consent agenda. We got a little more work to do before we move those forward for approval. They're not going to impact our ability to keep those projects moving. We just, before we take action on it, we want to get them in a little better state.
Oh, okay.
Motion to approve the agenda with
the two
deletions.
removals. How's that? Yeah. All right, we have a motion and second. Any further discussion on the board? Anyone in the audience? Seeing none, all those in favor? Aye. Motion carries. Now, this time, we will entertain public comment. If there's something on the agenda that you would like to comment on, you certainly have an opportunity to do it now. You will also have the same opportunity when that item comes up. So if it's an item that's coming up later, you might want to save your comments to then, but you are welcome to come up at this time. You'll be given 3 minutes. As you come up, please, ma'am, come forward. Please state your name for the record, and you will spell your last name, please.
Okay. Julie Allen, Allen, and my family has the home at 100 Birmingham Street, which is on the corner of Headland Avenue and Birmingham Street. And I would like to read a letter from my mother, who is unable to attend. Dear Commissioners, I'm having my daughter, Julie Allen, read this letter since I'm unable to attend due to being the chief inspector for my precinct. I've been a landowner and taxpayer of the Sea Highland community since the early 1970s. Sea Highland was developed in a way that the public would have access to the beach. Headland Avenue has been a road that went all the way to the beach bluff. The plat illustrates this, and I have these to pass out. Note the beach access for Greenwood and Andalusia are also included on the plat. For 40 plus years, there's been beach access at the Seagrove Villas. After Seagrove Villas was sold and the new houses built, access to the beach has been lost. Reference also the covenants for Sea Highland for some violations for that area on that end. I ask you to listen to all the facts and not exaggerations. The plat shows the county road, Headland Avenue, going to the bluff. The county owns the road and should correct the issue of encroachment by beachfront property owners. I've experienced a similar situation with Whiskey Bravo's encroachment on the right-of-way, and the commissioners did nothing. It is time for the commissioners to uphold the rights of the public and to vote for beach access since there is overcrowding in the area, more development to come, and a beach access was lost with the closing of the Seagrove Villas. I ask that the commissioners vote to correct the encroachment issues on Headland Avenue and to vote for Headland Avenue beach access. Thank you for your consideration in this matter. Sincerely, Barbara Sutherland Starr.
Thank you, ma'am.
And so,
if you give it to the clerk, please. Mr. Bryan. As Mr. Bryan comes up, I did fail to do something that is most important. I failed to wish Mr. Infeld a happy upcoming birthday this week. He will be years old. Happy birthday, sir.
Younger than Donald Trump.
Yeah, younger than me, but we won't go there. So, Mr. Bryan.
Yes, I would wait until the item comes up, but last night we lost a great woman, a great mother, a great grandmother, and a great great-grandmother. And so I want to get home and be with the family.
Certainly, and it's B-R-Y-A-N, is that correct?
B-R-Y-A-N,
Thank
yes,
you.
ma'am.
Yes, sir, go ahead.
I simply cannot understand why you pass the customary use ordinance when you're still tinkering with it, when you're asking. But it seems to me it would be better to let that pass, see what has to be said. I also have an objection to not hearing from Mr. Thoriak during the course of all of this on his findings. We paid him a great deal of money, and he should have come back. We should have heard what he found, and so, you know, I would really like to see us do a little better about this stuff. Thank you.
Thank you, sir. And you have our condolences, sir. Yes, sir. I was like, if this is on Headland and you have a map and all, it might be prudent to wait till we discuss the matter, or?
You can, either way. I mean,
Yeah.
either way is fine.
Here are exhibits. I'll let you decide if you want me to speak now or not. It's up to you.
Well, you're up here, go ahead.
My name's Richard Butela, B-U-T-E-L-A. I live in Seagrove Beach. Thank you for the opportunity to speak on your busy schedule. First of all, Headland is not a breezeway. On the picture on the screen there, you can see that it's been used by vehicles, and that's circa like I was just told circa late 50s, 60. You can see that was a road from the beginning, and it is a county maintained road. And then the next picture, you'll see overcrowding, seen in the summer at Greenwood Beach Access. Greenwood is a block east of Headland. Notice that there's no cars or golf carts there. That has been a concern of some neighbors there. Just a lot of bicycles. There have been quite a few big houses built, which I'm sure you're aware of. We have one right on Birmingham, which is near Headland, which can accommodate over 20 people. Just the people from that house alone can pretty much fill a beach access. We definitely need this beach access.
Would you mind speaking up just a little bit?
Oh, thank you.
It's hard to hear.
Okay, this is a county survey showing the access. The yellow is all county property. Actually, the county public beach actually starts on top of the bluff, includes part of the bluff. You can see obstructions from plantings by people in this drawing here. You also can see a private walkway which has basically gone through into the public walkway. Now, thanks to the efforts of the BCC, this fence was just removed, and we appreciate that. Here's a map showing, a survey showing the new house there. Only has a 1.3 setback. That's a that's a very small setback. And that's the same owners that put the obstructions in that location. This is a blow-up of the county survey showing Headland and Montgomery. Headland basically offers us opportunity for a safer beach access than most on 38 because it opens onto a neighborhood road. Also notice that the stop sign here also enhances the safety. If there is still concern about safety, Montgomery Street right away is 40 feet wide. Let me stop.
Mr. I will give you another minute to finish up and then.
Okay, thank you. It's 40 feet wide, county right-of-way, so the road could be widened to a maximum of 40 feet, depending on the county engineer, of course, to increase safety and visibility on that corner. I noticed that I was not at the July 12th meeting, but Then also the owner of Whiskey Bravo said he opposes the beach access because he's concerned about beachgoers using his private parking lot. You'll see a picture up there of the a bulldozer clearing the county property. My understanding, I was told by code enforcement that that was unauthorized and it was done privately. And in the next picture, you'll see pictures of parking, that being used for a parking lot. Initially, there were cones put out there by Whiskey Bravo to reserve that property. And they also, the owner of Whiskey Bravo also contended that North Headland is unsafe. Well, that North Headland's been used for decades.
All right, thank you, Mr. Vitelli. You can bring it up again when the issue comes up.
Okay, thank you.
Is there anyone else? Yes, sir. You would state your name for the record and spell your last name.
Mansell White, W-H-I-T-E, resident of Seagrove, Montgomery Street. I'm reading a letter here from Skip and Victoria Moore, who own Whiskey Bravo, that they sent to me the other day and asked that I read here at the meeting. It is with regret that we are having to provide our views again as it relates to the preposterous notion that Walton County needs to have another beach access at Headland Avenue in Seagrove. First of all, let us dispel the idea that we are elitists that have the problem with people having safe access to the beaches of 38. We actually live directly adjacent to one of the busiest access on 38 and operate our business adjacent to another public access on 38. Our issues with the proposed beach access at Headland are the same that we've discussed ad nauseum. Headland is not suitable or safe access for anyone. We can easily demonstrate this and will testify that Headland Avenue is significantly a safety hazard when two cars try to pass in opposite directions. It's also a hazard from cars blindly turning from Headland to 38. Those who would put pedestrians, including children, in harm's way for the sake of having a redundant beach access are surely misguided at best. Additionally, Whiskey Bravo and 4 other businesses operating on our campus employ between 70 and 75 Walton County residents. Businesses that operate on our property generate revenue from patrons that utilized our parking lot. We currently have an epidemic related to neighbors and renters of neighbors parking on our lot, depriving space for our customers to go to the beach via the public access crest directly to our west. Whiskey Bravo and 4 other businesses do not have employees park in our lot to allow patrons to utilize every space. If there were another beach access, which by the way would be less than a football field away from the current access, we would have to implement a plan to cordon off our parking lot, forcing traffic primarily on Montgomery, Gardenia, and Grove Avenues. The effects of the residents of the neighborhood would be immediate and very disruptive. Lastly, the Board of Commissioners has addressed this matter numerous times with the same results. This should be the end of the discussion. Everybody should move on to more important matters affecting the county. It should be apparent, given the results of the recent primaries, that the Walton County constituency wants commissioners that represent the majority of residents and doesn't pander to a loud, overzealous minority. Common sense should prevail here, and there should be no further discussion putting unsafe, costly, and unnecessary beach access on Headland. Thank you, and please move on. Skip and Victoria Moore, Seagrove residents and owners of 723 Whiskey Bravo. In addition to that, it was stated earlier today that this was previously an access. That's a falsehood that's been repeated ad nauseum and many times in this room. There was never an access at that green space at the end of Headland Avenue. And the county has never, ever accepted any responsibility for that space. And there have been many grievous issues of flooding and beach erosion that have occurred there, and the adjacent property owners have had to shoulder the extreme expense of that. So it's crazy for the county to all of a sudden claim that it's public property now. Thank you.
Thank you. Anyone else? All right, seeing none. Are there any additional items that we want removed from the consent agenda for discussion? If not, could I have a motion to approve the consent agenda?
So moved.
Second.
Motion and second. Any further discussion?
Aye.
Seeing none, all those in favor? Aye. Motion carries. Next, we have the Waste Management EAL.
Madam Chair, I have a conflict of interest. I filed the proper form with the clerk. I will
Good.
abstain from the vote.
Do I have a motion?
Motion to approve.
Motion and second to approve the EAL. Any discussion? Anyone in the audience? Seeing none, all those in favor? Aye. Mr. Jones.
Thank you, Madam Chair and Commissioners. The first item on our agenda this evening is a report from Mr. Steve Hall. If you recall, we asked Mr. Hall to prepare a report for you regarding quiet title and quiet title actions on the beach properties within Walton County. And he's prepared tonight to make that presentation to you.
Okay. And Mr. Hall, before you get started, I need to, in case, I think most of you do know, but if any of you were here and saw Dalton Drive, we had at 2:30, but it's also on the planning agenda as well. If you're here for that issue, it has been moved until January the 10th at 2:30. January the 10th at 2:30, that issue, quasi-judicial issue, has been moved. So, didn't want you to stay all night and keep waiting for us to bring it up, and we didn't. So, Mr. Hall, it's all yours.
Madam Chairman, members of the Commission, my name is Steve Hall. It's H-A-L-L. My firm is Hall & Runnels, and we've been working for several months at your direction on the issue of quiet title actions and how they're impacting, especially the beachfront areas in South Walton. I want to make sure at the outset to say that I'm not here to lecture you on quiet title issues and the law. I'm very interested in responding to your specific interests and questions. So if you have a question at any time during my presentation, please don't hesitate to ask. I'd prefer to direct the information to your questions as much as possible. Just to make sure that we're on the same page, it's probably a good idea just to describe what a quiet title action is. In the state of Florida, it's actually a statutory cause of action created by Chapter 65 of Florida statutes. And essentially what it does is it establishes a legal proceeding to establish an individual like myself's right of ownership over a piece of property as against an adverse claimant. In other words, Madam Chairman, if I have a 10-foot strip in the back of my yard that you also happen to claim as an adjacent property owner, it provides a mechanism and a place for me to go and seek a judge's declaration as to who has the higher quality or better quality of claim to that 10-foot easement. It also provides an opportunity for a landowner who has a concern about something that's come up in the public record. Say when you're buying or selling a piece of property, you get a title search, and there's a badly described easement or an ancient claim of another sort. It gives you an opportunity to go to court and basically ask the judge to make that same declaration as to the validity of that cloud on your title. So it's probably most important for me to explain the last part of what's on the statutory description of quiet title actions. And I'm doing this to kind of shorten the presentation. The most important thing for the board to understand, and really for anybody who's looking at quiet title actions to understand, is that the statute and the following case law establishes that only the people that are brought before, or the entities that are brought before a court in a quiet title action, can have their property interests negatively impacted by that decision. If you think about it, due process of law. In the United States of America, you can't have your property rights taken in general, constitutionally, without the ability to appear before the trier of fact and make your case. So anyone can start a quiet title action against anyone else who they think claims or has an adverse claim to their piece of property. They are not required to join everyone who might have an adverse claim to their piece of property. And you'll see why this is important when we start talking about the South Walton cases. So it's very clear in the law and in the statute and case law that if I am not a defendant in a case, the judge who issues that final order quieting title cannot impact my property interests. Let's move forward. The type of actions that involve quiet title and the kind that we're going to talk about are generally two. They're restrictive covenant interpretation cases, and you'll see the first couple of cases involve these older plats along the coastline. They aren't necessarily as detailed or as clear as the modern era plats that you're used to seeing in your daily work. The conflicting interpretations of the restrictions that come along with those plats are just a real fertile source of potential litigation in the quiet title arena. Then secondly, you see a lot of easement-related, access-related quiet title actions. Does the inland property owner have the right to access a walkway next to my house to get to the beach? That is an implied easement or an express easement or some other easement which is created by adverse use that the court can rule on. So am I interpreting plats, restrictive covenants, or am I interpreting easement rights, access rights through a quiet title action? The plat interpretation cases are some that you have seen and heard about over the last few months, especially the first and second. The first is the Rodell versus Blue Gulf case in the Blue Mountain Beach subdivision. Excuse me. The second is Fitzpatrick v. Beach Highlands Corp., which is the Beach Highland subdivision. And then probably for the next most popular, thank you very much, is the Sea Highland subdivision case, which has recently been decided, called Israel v. Pender. So I think if we can go through those cases one by one, it may help clear up a couple of questions that you've heard through public testimony and that really have jump-started a lot of this conversation about customary use. And then there's one particular case, and I'm not bringing these to you as every quiet title case that's out there. I'm bringing these to you as kind of teaching cases that will help you understand them generally. The final case is one that's still active and has recently had some judicial action in it. It's called New and Tippins v. Bradford, and that's in the Gulf Trace subdivision. So let's start with the Blue Mountain Beach case very quickly. I'm going to go ahead and move to the plat picture. The plat was recorded in 1948, and like a lot of these early plats, shows the area between the seaward edge of the platted lots and the shore of the Gulf of Mexico simply as beach. In some cases, capital B-E-A-C-H, but just beach. And this was notable during this time period in the early 40s, early 50s, a pretty standard way of platting and then dedicating. There's no clear dedication in this particular plat of the beach area to the public. There is a dedication on the face of the plat that deals with roadways and parks, but it doesn't specifically address, with a capital B or anything else, the nature of the beach. Basically, the situation that led to this case is the developer. You have to remember another basic point of law. When someone dedicates something to the county on a plat, dedicating it to the public, they don't transfer title to that property. In other words, Walton County doesn't become the fee title owner of that land. That land remains in the developer. Now, the developer or whoever the existing landowner is. The public gets a right to use it, to maintain it, improve it for roadways, but the fee title stays in that grantor or dedicator on the plat. In this case, the developer records a covenant in 1955, which was not quite 10 years after the deed was recorded. He promises to deed the beach area to owners of lots if the development company is dissolved or the property abandoned. The case begins here with the developers being long gone and with just that covenant out there in the public record. So you got a promise from the owner of the property in public record that says, bottom line, we will convey the beach area to lot owners if we ever dissolve. They've now dissolved. So the the lawsuit here is not actually a quiet title action, it's a declaratory action, and it's a covenant enforcement action. And it says, Judge, we own property right here in this particular section in Block 11 of the subdivision. The developer made a promise to convey this property to us in the beach area if it, under these circumstances have happened, and now it's time for you, Judge, to declare that promise should be kept and that those areas need to be conveyed to us as beachfront property owners. And that's what the judge did. It was actually a suit against the possible heirs of the developer who were never heard from. So the court appointed an ad litem attorney, a third-party attorney, to represent the interests of the development company. In this case, I'm not sure why, and I'm not sure about the details, but I don't see a lot of defenses that were raised by that ad litem attorney in this case. So basically, it was a summary judgment final order that granted title to the beachfront property owners. Now, it's important to note, remember, that title was conveyed to these beachfront property owners by a deed that came out of the court. But this court did not address the public's right of use to these parcels in this beach. Just to give you an example about the way things turn out, if you look at that next page, you go to the property appraiser's site and you can click on and see who owns property and who does not. Those red parcels, this was done just the other day, those red parcels are beachfront parcels within that subdivision boundary that are still shown as beach, just capital B-E-A-C-H. No other ownership, no other title. So something has happened with the rest of these lots outside of this particular block that the property appraiser thinks that these areas of the beach are now owned by the adjacent property owner. To the Beach Highlands subdivision is a lot of the same story, and it involves the Beach Highlands subdivision. Again, it was a plat that was filed in the 60s. Shows the same kind of area, marked beach. No dedication to the beach on the area, on the face of the plat. The development company was dissolved in approximately 10 years later without conveying title of the beach to anyone and didn't designate a successor. Now, in this case, the company officer, as a part of the Beach Highlands Corp., after the dissolution, put out an affidavit and recorded in the public records that says the intention of the developer was to convey these beach areas to the adjacent lot owners in these blocks. Based on that, suit was filed against the successors of the Beach Highlands Corp. No answer. Ad litem attorney was appointed, admitted to the items of the complaint. Judge issued a final order, which was to convey title to those beachfront areas that you can see in the blue outline there to those adjacent upland property owners. Expressly also included one condition, which said it also their use was subject to the owners in the inland portions of the Beach Highland subdivision. So again, Walton County wasn't involved. The issue of public use of those beaches was not discussed and ruled on either way in the Beach Highlands case.
Steve, if I may.
Yes, sir.
That access point that comes in there to the beach, I believe is probably maintained by the county. Jay, is that correct? I mean, do we do anything there? Is that Brian? If that is the case, would the county or should the county have been notified of this action before it went to court so we'd have an opportunity to object or whatever the case may be?
Mr. Chapman, that's exactly the point I was making earlier, which is whoever files as a plaintiff, in this case all these beachfront owners, are not obligated to notice anyone who may have a claim that they're trying to quiet, or they may have a claim against the property that they're trying to quiet. In other words, I can quiet my title against anybody, but I don't have to do it against everybody. So if the county is not involved as a defendant in the case, then the judge's order has no impact on any of the county's use rights for property it owns, property that's been dedicated to the county, or basically public rights that you represent as the local government. So, easy answer, the judge didn't rule on that because it wasn't in front of him.
How does, question, how would the county be aware of these issues if they're not required to notify anybody and the county's interested in this public beach? How would the county be notified?
Well,
Or could they be notified?
It's part of my recommendation to you generally, because I know the county attorney administrator don't necessarily want to make specific recommendations in cases in open session. But my general recommendation is that there are ways to monitor the cases that are filed in the local circuit court. For example, it's what I've been doing on behalf of the board for this last period of months, just looking at filings, looking at notices published in the newspaper.
So this is subject to the use rights of all the lot owners within the subdivision. So everybody in Beach Highlands 1 and 2, even across the road, would have rights here? Is that what that means?
Now, the judge's order specifically referred just to the rest of that interior area of the Beach Highlands plat that's shown on the drawing that's up on the screen.
Oh, just the south of 30A area?
Correct.
Okay. But if the owners north of 30A had, I think it's difficult to understand how somebody can just do this and not notify anybody of it.
Well, and that's why I brought up that point. Now, I know it's hard, it's hard to get in context, but the issue is that the public rights, or even the rights of people north of 30A, were not at issue in the case. The
so
lawyer,
that would have to be another case. Is that what you're saying?
Because,
can you challenge these quiet titles if you're affected by them and not noticed?
Well, civil procedure allows any party, the county being a party, a potential party, to intervene in a case.
Yeah.
In other words, I know this is going on, and I think what you're saying is going to impact the county's property interest in this dedicated plat, so that we can come in and the court has to approve that intervention.
Right.
And we'd have to the county would have to provide standing information and would have to prove that it deserved to be in the case.
Right. But then after it's done, you can't intervene after it's done, can you?
The answer to that is that if these private landowners who have received a quiet title in relation to the development company and has fee title, and they start acting in a way that is contrary to the way Mr. Chapman raised the question, the way they start blocking the public access or blocking the access way that's shown here in the middle of the plat, then the county has the ability to do what the county has done in other situations like this, which is remove the gate, remove the wall, open the use back.
I think in this case, Bullard, which has been used as an access, the people around there hired a lawyer and basically sent us a letter saying, don't touch this or we're going to do something legal. So
the fee title ownership conveyed in this case does not in any way expressly affect the county's interest in that area of Market Beach.
So when did the company officer, in this case, record an affidavit in the public records saying the intent was to dedicate the beach to common use of lot owners? And when do you have that date?
I do.
When did that happen?
It was not contemporaneous with the plat filing, but it wasn't too far after.
Oh, okay.
It wasn't and I should be clear in this case, if you're interested in the next level, one of the members of the corporation I guess was distributed some of the lots to sell individually.
Okay.
And as a developer, sold those lots to a number of these lot owners within this block that were plaintiffs. And their deeds were also evidence before the court. And these deeds from this former member of the corporation said to the water with full riparian rights. Lot 7 to the water with full riparian rights. So he sold and deeded out a number of lots subsequent to the declaration that showed rights down to the water. So it was not only the affidavit, but it was the deeds themselves that added to the case.
Now, who gave him the riparian rights?
The development company would have originally purchased that property that was platted back in
60.
Yeah, back in 1960. I'm sorry, I've moved to another slide there. Hold on.
That's okay. Yeah, plat filed in 1960.
Whoever conveyed that property to the original development company included that beachfront area, the area that's marked beach on the plat.
Okay.
And so they owned it at the time of platting, and they retained title. The problem was they never properly got rid of it.
Okay. So I guess at what point in history did beach land began to be, white sandy beaches began to be sold off to private individuals? Or is that a question for another day?
Well, it's a pretty broad question. The properties that have been sold by meets and bounds descriptions very often included a description down to the mean high water line.
Okay.
The bulk of the lots down there on the Gulf were sold either in condominium units later on or in these platted lots early on.
Okay.
And the trick is that in a lot of these old plats, and you can go through the plat book and look through Seagrove, look through Blue Mountain Beach, and they were all basically platted with a beachfront area that was wide open, and the lots were not platted down to the waterway.
The beach. Okay.
Now, this happens in relation to a lot of waterways. The city of Valparaiso, for example, is platted in this same classic form that the lots go to a roadway, which is a beachfront parkway, and all the land on the waterward side of that parkway was left open for public bathing.
Yeah. Okay.
Now, over the years, the city of Valparaiso has changed all that, but this was a pretty common way of platting waterfront property up through the 50s and 60s. Okay. So, but that's why I wanted to make that point early on, that your rights are not determined negatively unless you are brought into the case. So the county's rights or the county's representative rights in the public in that blue area in the Beach Highlands plat has not been determined by the court.
Okay.
Just because you have fee simple title doesn't mean you can control the property.
Really?
Well, I'll give you a good example.
Because we're being told that, well, by certain people that they have fee simple right and they can control the property, and
let's talk about Sea Highlands.
Okay.
I mean, that's the perfect. We'll skip over that interim case and look at the Sea Highlands case very quickly.
Okay.
That's recent, and it's we've already talked about it. And talking about a beach access way at the other end, at the western end of it, so it may be relevant for you.
Okay.
Now, Sea Highlands, and you can see the plat. Probably familiar with it. It was one of these plats during this period, which was really the exception that proved the rule. In 1949, it had that same kind of platted lot, publicly dedicated roadway, and the beach, which says beach reserved for public, expressly on the face of the plat.
Okay. Yeah.
So in that case, you had the same time frame, same kind of developer, but they chose to be very explicit about what that beach use and what the roadway was going to do. So it included an express dedication on the face of the plat to the public.
Okay.
Now, here's the trick. The county has improved those roadways at least 3, I think, that have current improved beach access ways coming down to the beach from the end of the roadway. Nobody's contesting that or the existence of those particular accesses. The finer point of detail is that these lots, if you look between each lot, you will see a 20-foot wide space. And you've heard somebody reference tonight already the term breezeway.
Yeah.
So this was platted. The dedication does not expressly refer to alleys or breezeways. It just refers to roadways and public places. So there's an interpretation now that's been brought forward by one of these property owners who is a beachfront property owner. And I think in relation to a dispute and a question over an existing beach access walkover that had been either destroyed by a storm or was badly in need of repair. These owners came and said, in response to, I think, the action of the county commission and an inland property owner, to rebuild that walkway down that breezeway, to use all the right terms. Basically, he got a DEP permit to rebuild it. The county gave him a license, essentially, to access the breezeway and rebuild the walkway. They filed an action, this same landowner filed an action against the county and the inland property owner. That was their initial action. Judge, immediate injunction, you got to stop them from building or rebuilding, but they said building the access way. And that was their original pleading. And asked the judge to quiet title in them and also make it clear that neither the county or the inland property owner had the ability to build a structure in that breezeway. So that was a fight. They got up about to the end of the jury trial, the judge trial, and dismissed the case. I guess they were about to begin the trial. They dismissed the case against the county and the inland property owner. Left all those questions aside. They had filed a second action, the one that's shown here, Israel v. Pender, against the same kind of defendant we've been talking about, which is the descendants of the developer. So they go and try to find every descendant living anywhere they could find them as far as descendants of the developer, and said, we are quieting title against any claim that you people as descendants of the developer have in this alley, in this breezeway. Not against the county, not against other owners within the subdivision, only against the descendants of the developer. Only defendants in this case. This case went to final judgment. The plaintiff basically relied on this fact of platting, which says, when I dedicate something to the public, the fee title in these kind of alleyways or breezeways actually goes to half and half, in the case of the county, half and half to each of the adjacent property owners. So this 25-foot breezeway down here in the south and east corner of the neighborhood was divided half and half, the way that the law reads in terms of fee title ownership. The final order in that particular case very expressly states in 3 different places, so I think the judge was trying to make the point very clear, this judgment in no way impacts the rights of others beyond the descendants of the developer. Whether you're claiming implied dedication, whether you're claiming dedication by plat, whether you're claiming an easement because you prescriptively used it for 25 years, this case, this order, does not settle any of those issues in relation to this particular breezeway. Does that make sense? It's that same principle in place. Judge can only decide against the people who are in front of him or her. In this case, the only people that are involved in that final order were any interest the developer and its descendants might have in that 10 feet. So in no way, and this is the problem, people read this and go, fee title has been granted to, that's the end of these breezeways.
Okay, but that's not the case.
It's not the case.
So they could walk down, could they walk down the breezeway?
Well,
Could they,
I can tell you that this order changes nothing about what they could do or could not do before the case. Whatever they were doing before the case, they can do after the case.
okay. So why would somebody even file that if nothing's going to change?
What it does, the only thing it does is clarify that this lot owner has 10 feet of ownership within that breezeway.
Okay.
That's the only thing it does.
Okay.
Now, sometimes when I'm in a court, I really prefer to have somebody as a client who has a fee title interest to a piece of property, because that gives a presumption that you got a little more going than if you don't.
Okay, I got you. Okay.
But it does not give them a right to exclude anyone who had rights before that weren't dealt with by the court.
Does it give them the right to say that they can't put some steps down there and walk down them that they've been doing forever?
The idea is that whatever I could do or you could do or an inland lot owner could do within this subdivision in that access way has not been dealt with by the court.
Okay. One last question on my part. Could the public file a quiet title claiming any of the beach areas? Say I'm John Q. Public and I decide that I'm going to claim some beach areas that, nobody's really saying anything about or claiming them. Could I file a quiet title and not notify anybody, and on any given day, perhaps a judge might say, sure, it's yours?
The statute provides some basics in terms of prerequisites before you can file.
Okay.
And one of those prerequisites is that you have to be able to establish a colorable claim to the property.
What does colorable mean?
A verifiable interest in the property.
Okay. Now, what if somebody quit claims something and somebody comes out of the woodwork and says, oh, wait a minute, my grandfather owned that back when, and he never meant for this to happen, something like that. Can they challenge him?
That case comes up quite often in this under this cloud, clearing cloud from title. I bought this piece of property, and now I got this person coming out with an adverse claim to the piece of property.
Okay.
Judge, you need to tell us who's.
Okay, so
who's got
those are
superior
decided
right.
in the courtroom.
That's right.
Okay. I think that's my last question.
Commissioners, the only thing I would add is in the original case, the original C. Highlands case in Israel versus Pender versus Walton County, before it was dismissed, the county did assert. We did assert that we had an interest in the breezeways.
Right,
I can't even remember exactly what the nature of that assertion was, but we did make that assertion.
Well, they were called out as in the covenants and restrictions as breezeways for light, air, and
that's correct.
What
it was
have you.
basically for you could not construct within those breezeways.
Because
to allow for light.
They wanted the breezes to blow through everybody's house. Okay.
But
one last question.
There was a question raised by the county of whether or not by accepting the dedication of the remaining roadways within the subdivision, that they actually accepted those breezeways.
And I actually lied. I have one more question. How does this affect, or how does customary use affect this, or how does this affect customary use?
The last case that I had in your packet, New and Tippins versus Bradford, was actually the first one and actually the only one that I'd seen that expressly referenced a customary use argument. Mm-hmm. And basically this case, if you look, is an interior property owner on that Gulf Trace plat.
Right.
An interior property owner has sued a beachfront property owner who owns property adjacent to a beach access way.
Yeah, okay.
And the question in the case is that the inland property owner is trying to make a case before the court to establish that they have right to the dry sand portion, the use of the dry sand portion of the beach.
Okay.
They made two assertions. One, that they have an implied easement over the dry sand portion of the beach. And the second was a customary use claim that they asserted as also supporting their ability to use the dry sand portion of the beach. And there's some great arguments for those in the audience or otherwise that want to look a little deeper into the case law as it applies to quiet title, declaratory actions, and customary use. There's some great arguments in the memos back and forth.
Okay. Thank you. That was very informative.
Commissioners, anybody else?
If we have any other questions, we can find you.
Yes.
Okay.
I am available, and I hope I didn't over-lawyerize it for you.
No, it was good.
Okay. And we'd be glad to provide a more detailed written report or take any action that the board is interested in.
And if anybody in the audience would like to ask him a question, I'm sure he'll be available. I'm sure he will be available to answer your questions, between break times.
I guess the question is too, are we monitoring these now, or do
Yes.
we are? Okay.
Yes, we try to, it's not easy, but we're trying to monitor
Okay.
civil filings to make sure we don't have an interest.
Thank you.
Very good. Mr. Jones.
Thank you, Madam Chair. Next item is a request from Kevin Boyle with the Seaside Arts and Entertainment Group, and their request is to close both lanes of Highway 38 from Seagrove Plaza to downtown Seaside on November 26, 2016, from 4 till 5 p.m. For the annual South Walton Holiday Parade. This has been reviewed by the Sheriff's Office, the Fire District, and Public Works, and has received those approvals.
Is Mr. Boyle here? Yes. Yes, sir. Is there anything you'd like to add? No. Okay, very good.
Smart man.
Smart man. Do I have a motion or a second?
Motion to approve.
Second.
Motion and a second to approve. Any further discussion among the board? Anyone in the audience? Seeing none, all those in favor?
Aye.
Motion carries. Thank you, sir.
Thank you, Madam Chair, Commissioners. The next item is regarding the committee to provide recommendations or ideas to you on the customary use and the ordinance that you recently passed. And I must tell you that I think that we at staff level dropped the ball on doing what you asked us to do. I believe the direction was to review those applicants that were made and present you with a recommended list to sit on this committee, and quite frankly, we did not do that. And so for that, I apologize. But if that's the direction you'd like us to move forward with, we'll be glad to do that. But I will tell you, and maybe for separate consideration, we had 2 applications that were received post the cutoff time for the original. So it's whether you wish us to consider those or whether you wish to consider them or not. But
I don't recall us saying that we wanted staff to pick them. I recall us just saying, let's take applications and review them. I don't know where
I'm
that
looking
came
at the
from.
minutes,
but-
and the minutes say, Attorney Davis says, then we'll make Dee Dee, Mr. Jones, and myself would make the recommendations to you once we get all the applications. And then Commissioner Commander said, very good. And then Mr. Davis said, obviously, we'll try to have as balanced of a committee as possible. Now, I left here thinking that the committee was going to make recommendations. Now, I mean, I'm certainly, whatever the pleasure of the board, if you don't want to go that direction, I'm certainly open. I'm not.
And I can assure you that if we had had that clear understanding, we'd have been prepared, and so we do apologize for not, but we'd be happy to.
I think it was kind of loosey. It was loosey goosey because it kind of came up at the last minute, and it was kind of thrown out there.
I'll go with what everybody else wants. I have read all 25. I have.
I think one of them didn't. One of them decline, get out
Yes.
of it. Yeah. Okay.
Yeah.
Number 12 got out
Yeah.
of it. I think.
And I'm ready to pick my 5 on each side. But if y'all want to wait, it's up to you.
The
Well, I was
5 on
thinking
each.
maybe we list.
The 5 on each side. What side?
Well, I
do you
mean, we want, and that's probably a wrong term. We want beachfront owners representation, and we want non-beachfront owners representation.
5 and 5.
Yeah, say 5 and 5, 10. We can do less than that. you know, but Mr. Chapman, what's your?
Well, I was thinking, why don't we just have, since it turned them into admin, let the county administrator go through this, vet them, come back with a recommendation to the board of 8 or 10, whatever you direct him to do. Just have him come back to us at the next board meeting. I assume it can be done by then.
I believe so, yes, sir.
One of the things, though, is I think that a lot of these people are, a lot of these people we know, and a lot of these people we know where they stand and what they're doing. I'm not sure the county administrator, I mean, we're the elected body. I'm not sure the county administrator is, I mean, while I think that, you know, he could pick them, or somebody could pick them, I think the idea that we're the elected body and that I think we know this group of people better than anybody, I would say. Because most of them are from Santa Rosa Beach, to tell you the truth. There's one from Ponce de Leon, there's a couple from Miramar, but most of them are Santa Rosa Beach, so there wasn't a lot of variation, you know. I would suggest that you pick somebody from Miramar, somebody from Santa Rosa Beach. There was one from Rosemary Beach, you know, kind of spread it around.
Well, I think Mr. Jones is quite capable of going through this list and looking at it to see and vet it out. And even if he presents his recommendations, we always have the opportunity to override it or add to or take away. So I think we still got a dog in this hunt.
I think if you do that, you need to identify which ones are beachfront and which ones are not, because the list we got didn't really, I mean, it kind of showed you where some addresses were.
I think if that's the direction to go, we would certainly understand that we would want a balanced representation from those positions as well as the
Locations.
beachfront owners along the beach, as opposed to all in one particular area.
I think too, it's important to see how long people have lived here. I think that's important as well, and I think they should be local people. I don't know. I think they should be local people. I don't think they should be living somewhere else and kind of here, you know, maybe now and then maybe later. But it doesn't matter to me. It's up to you guys.
Since I'm the one who confused myself and everybody else, apparently, if it's just Mr. Jones, then he can come back and make a recommendation. But if you want him to have himself and somebody else, you need to say that and make that motion, and then we would have to have that group meet in the sunshine since there's going to be a recommendation. But if it's just going to be Mr. Jones reviewing them and giving you a recommendation, then you don't need to. Obviously, he can't have a meeting with himself, so there would be no sunshine law issue. I don't know. Larry could have a meeting with himself, but we just want to be clear that if it's just Mr. Jones or the county administrator make a recommendation, that the motion actually say that,
Yeah.
so we don't have.
I think it'd be interesting too. When I started looking at this, I started thinking, you know, some of these people have experience in rental management. Some of these people have experience in vendor organizations. Some of these people have experience in, you know, that it needs to be broken apart and say, you know, this person's got experience in beach services, or this person has experience in rental properties. And I think, because I think you need a cross section of all different kinds of people, not just if you live on the beach or if you don't. I think that
is the only way it's going to work.
Yeah, I think that you know, if you live on the beach or, you know, I just think you need to go a little bit more deeper into.
Yes, ma'am.
Somebody make a motion so that I can get public comment.
And lastly, let me say the motion, if it's going to be just Mr. Jones, would need to also say that ultimately the decision is the commission's on who to place on the committee.
All right, I'll make that motion.
Is that what you just said? All right.
Second.
I have a motion and second. We've discussed it. Is there anyone in the audience that would like to comment? Mr. Brook, if you'd come forward, please, state your name and spell your last name for the record.
My name's Bob Brooke, B-R-O-O-K-E. It appears to me that the discussion that's just gone on before the board, by the members of the board, begs the question that you have no criteria for making any decisions, and to leave that up to the county administrator without any direction as to what criteria he should use makes no sense at all to me. I think the first thing you need to do is establish some criteria for the people that you're choosing to be on this commission, board, committee, whatever you're calling it, before you go any further. Thank you.
Thank you, Bob. Anyone else?
Good afternoon, Commissioners. Mars, M-A-R-S-E. One, I've served on a lot of committees. It's best if you have an uneven number than an even number on this committee. You have 10. Is that what you're saying?
That's what we're discussing, yes.
You're discussing 10, okay. The other thing I did not hear one mention, you said the residents in the south part, are you including anyone from the northern part of the county?
Ms. Morris, if they have applied, then,
Okay.
then yes, ma'am. If anyone applied, we have their name here.
Okay, well, as a question then, do you have any applications from the North County?
There's one. There's one.
Oh, just one? Okay.
There's one from Ponce
Those are
de
my
Leon.
questions. Thank you.
Yes. Anyone else? Mr. Hudson?
That's
For the record, my name is Bob Hudson, Hudson. It was my understanding, and I support what you're doing. I think you, as commissioners, owe everybody that's involved in this situation the best opportunity you can to avoid pending litigation. I don't know that this committee is going to make any recommendation that is going to avoid all litigation, but you may avoid some. And I think I commend you for trying to do that. Ultimately, this is not a taxpayer issue. When I say taxpayer, I mean Taxpayers Association issue. But once you get over into wholesale lawsuits, I think it does to some degree. So I wholeheartedly support what you're trying to do. I do think that it should be representative not just to beachfront owners, because there are people that use the beach that don't own property on the beach. I think you should take into account people who own property here and may rent it. That has been a model in Walton County for a number of years, and it's going to affect them. Some of those people could be realtors or whatever it happens to be. And I think you should have, if you have people who have applied that are from the north, from the south, from wherever it happens to be. And I think it should be representative, and I think it should be an odd number. But I wholeheartedly support what you're doing. I just hope that we can find a way to find something that would minimize or alleviate some of the lawsuits that may come from this. Thank you.
Thank you, sir. Anyone else? Yes, sir.
While he's coming up, I noticed another thing too, is a couple of these people said they represented larger groups. So you need to take that into account if, are you...
Yeah. And that's, I think we'll, after we get comment, I think we do need to very briefly list some of the criteria that we think is important. Yes, sir.
Hi, my name is Tim Verts, V as in Victor, ERTZ. Literally, I just wanted to...
I'm sorry, would you slow down and spell that?
V as in Victor, ERTZ, Tim
Thank
Verts. I am a property owner in Seacrest Beach. Literally, I just wanted to introduce myself. I'm one of the 25 people that applied for the committee. It is certainly an area that I know there's a lot of different opinions, a lot of passion on both sides of this, but it's certainly something that I'm very interested in and have been following for quite some time.
What was your name again?
Tim Verts. Thank you.
All right, thank you. Anyone else? I do think Mr. Hudson and Mr. Brook are right. We need some basic criteria. I think the only reason that I was going with an even number so that we would, maybe be balanced representation. Yeah. But I do think it's important that we have beachfront owners. We have realtors that represent
I think
rental
you need,
units.
You might need to do it like you do one of the boards that we have, like there's a realtor, there's an architect, except, maybe there's a vendor services, there's a realtor, there's a beachfront owner, there's a non-beachfront owner. there's you know, what other categories that they fall into is maybe just, you know, maybe two
Longevity
people
in the
from
county.
longevity in the county,
Those that are familiar with beach issues, maybe, I don't know. I'm just throwing
Longevity.
stuff out and say on the wall, see if it'll stick.
yeah, longevity in the county, or I noticed too there were a couple of attorneys that applied.
So that's a bad thing? No.
No, and the only reason I mentioned it is because, and a lobbyist too, is that, you know, it's prone to go to be a court case. I'm just throwing that out. I don't know, but and then have one from Miramar. Maybe have a beachfront from Miramar, a non-beachfront from Miramar, a beachfront from Santa Rosa Beach, a non-beachfront. You know, divide them up, and then have maybe a realtor and a vendor services and a rental property person, or you know,
And perhaps somebody from north of the bay, so.
yeah, and have two people north of the bay.
Okay. We have a motion and a second on the floor. Is there any further discussion?
What is the motion?
Now you ask me. The
I
motion was to.
I actually wrote it down.
Oh, good.
So just so we're clear, the motion is to ask administration through Mr. Jones to come back with a recommendation, him alone, on who the members of the committee would be, and that ultimately the board would make the decision on who the members of the committee would be, and that we have a list of criteria that have been stated out loud for him to consider.
Yeah, I would say that for him to amend that to say that Mr. Jones comes back to y'all with the criteria, the different people, and then look at who has applied and how they fit into that scenario. Would that work? So that you're not just, criteria is not just kind of thrown out there. And I think we should decide that now, but basically, or y'all should decide that based on what Larry's.
My only concern is if we put this off another 2 weeks, and in another 2 weeks, we're running into, you know, we said the customary use ordinance would take effect when?
April 1st.
April 1st. So we really need to get this committee started, and at least in December, if, you know, as soon as possible, so.
Well, I would offer an amendment to that, to say, one beachfront, one non-beachfront owner from the areas Miramar, Santa Rosa Beach, and East South Walton, which would be, you know,
Inlet Beach.
Seacrest, Inlet Beach, Rosemary Beach. So that would be 2, 4, 6. Then one vendor services, that would be 7. One realtor, that would be 8. What else did I say? One property management company, that would be 9, or one person who has rentals, that would be 9. You could stop at 9, or you could go 10, and then 11. 2 people from North Walton would be 10 and 11.
Well, I firmly believe there needs to be somebody representing the north end of the county. Unfortunately, all we have is one that's made application, and she's from my district.
Well, you could ask for more. You could ask for some more people.
We can keep the application, I assume, process still open, and there may be some additional ones that come forward after tonight.
I think the application process closed.
That's what I mean.
There was a date on it, and it has closed.
But you could open it back up, couldn't you?
All right, we're getting.
That's my amendment. Does
Okay.
anybody accept my amendment? Nobody accepts my amendment? Okay.
I think you're right. I think there needs to be, you know, rentals and not, you know, rental unit. But I'm more leaning toward, he knows what we want. Let him try to vet those.
Glad to.
You know what we, so you know we want a rental person, you know we want a beachfront from Miramar, you know. And as you look at them, try to bring those back to us that kind of fit into what we're looking for. I think hopefully you know by now what we're looking for. Okay. Okay.
Whatever.
All right. All those in favor?
Aye.
All right, and we will move on.
I just have one more thing. Under B, it talks about the purpose of this committee. I was just wondering what the board would think of an independent, out-of-town person, maybe a mediator or a facilitator, someone that is really not connected to this issue, not from Walton County, someone outside the area that could facilitate the meetings. And what I have envisioned is like a facilitation session, and let's talk about signs, let's talk about accesses, let's talk about how can the county improve enforcement on the beach, and come up, and then of course the dry sand area, let's do last, and try to find the things that we could agree on first, the committee could agree on, come to some kind of consensus, like the signs could be at the toe of the dunes, the signs could be a certain size. I mean, I'm just giving you that as an example. But I think if we had a chairperson that could kind of steer the conversations, we would get a lot more accomplished. And then once you settle an issue, like you decide where you want signs, for instance, then don't go back to it. That's settled, mark it off, and then go forward until, we might not reach consensus on everything, but there might be some things that we could agree on up front that would be good recommendations, and then carry forward. That was just
If we're going to hire a facilitator, we're going to have to advertise. Which will, right?
No, I think that would be considered professional service.
One of the things too is I think you want to limit your scope. If you're going to talk about signs and vendors and all kinds of things, you're going to get into the weeds fast. If you just talk about customary use and how you're going to, how it's going to work fairly for everybody, or for the majority of people or whatever. And I think you got to stick with customary use. Now, if people say, well, I want to put a sign on my property and that's part of customary use, then that would be a good thing to talk about. But if you expand it into all these other areas, you're going into the beach activities ordinance.
That's exactly right.
You're going into the beach activity ordinance.
Except that all of these issues that I mentioned are part of the customary use. The homeowners feel like they have not been heard about enforcement. They have real issues, real concerns about people coming up in their yard. I just think that if you, not to get in the weeds, but if you limit it to, and the facilitator could help us come up with a very slim list of things that do apply to customary use, I think it could mean for a good communication. I mean, I feel like people feel like we're ignoring them and that they don't have a voice, and I think we need to vet everything we can within 2 workshops, I think. That's just my opinion.
And the sign, though, is the leave no trace ordinance. It's a totally different ordinance. It has nothing to do with customary use.
Without a sign, how would anybody know if they were up on the landowner's property or not? I mean, and if it's the toe of the dunes, and we have our ordinance that says this far from the toe of the dunes, then we should delineate somewhere. Somebody should be able to delineate where the property line is. I mean, it's my, whatever.
Madam Chair,
Yes, sir.
I'm in agreement with a facilitator. I think this is such a emotional issue on both sides of the fence that unless there's somebody there independent that hasn't really got, as I always say, a dog in the hunt, then it would probably flow a lot better and be able to maintain control and direction of that particular committee. So if it's not requiring any additional delay, and it sounds like council thinks it's probably considered part of professional services, that we go ahead and if we need a motion for that, council, do we?
I think we do.
Yes.
Then I'll make a motion that we reach out and hire a facilitator to oversee and run this particular committee.
Second.
All right, I have a motion second on the floor. Any more discussion among the board?
Well, I think that Commissioner Meadows was right in the fact that many of these things are outside of the scope of what the customary use was. We haven't given the committee, let alone knowing who's on the committee, the opportunity to form and see if they can come to some kind of agreement. I think if they recognize right away that they're stalemated, maybe come back and ask for a facilitator because of frictions. But I think that the one thing we asked them to do was on a use with regards, a committee with regards to customary use. And the other things that have been talked about are either under the leave no trace or under the beach activities ordinance. And so I think we're throwing that committee under the bus before they've had a chance to meet. I'd like to see them at least have a chance to meet. And if they can't find a way to come to a common ground or some rules of engagement, then come on back and tell us we need a facilitator.
Okay, so would you say that the chairman would need to be voted on by that group, and out of the 8 or 10, however many are there, a person needs, I mean, you gotta have somebody in charge.
Well, they're gonna have to have the committee, they can select it themselves, but I mean, they're gonna know from their early discussions whether or not they are so fractured on the customary use issue that they should come back to the board and say, we need a facilitator to help see if we can bring both sides together.
So why wouldn't you try to find some common ground on some issues before you get to the, I mean, if the homeowners feel like that there's gonna be more enforcement, I mean, it could really end up affecting the end result, so.
Well, I mean, suppose one of their recommendations is, and it pertains to, let's say, the beach activities ordinance. We certainly, as the board, could accept that and consider that as part of the recommended solution. Did you want to pursue that or not? I'm not saying it excludes it, but to go out and to charge them with that up front when the initial charge was to deal with customary use, I think we're taking away their good intent, which 25 or 27 people have signed up and said, yes, I want to be part of that good intent. Let's see if they can. They'll know early on if they're so fractured that they can't. Then they can come back and say, hey, we got together and this is going nowhere unless we get a facilitator. And I think that would be the time to appoint a facilitator. That's
Yeah, I agree. I think the sheriff too, the sheriff has, the enforcement of this is, it's not going to be the BCC, it's going to be the sheriff's office. So I think the enforcement issue is really more of a sheriff's office, and if you stick to the customary use issue and narrow it down and focus on that, I think you could keep it together. But I think if you get too far off track, and start having a facilitator, and then you're going to be into the summer, and I mean it's going to take off like everything else does, and you're going to be past April 1st. But that's up to you guys.
Well, I guess that's the only reason I would maybe a facilitator, because that way they wouldn't have to elect a chairman. So it wouldn't be a beachfront owner or a non-beachfront owner. You would have somebody who's neutral. I do think some of the issues that Commissioner Jones is talking about, the commission itself actually needs to have workshops on. Before tourist season comes again, before we have vendors on that beach, we need to make some hard decisions among us. But I will agree with the facilitator. But if we can get one on board, how soon can we get that done, Mr.
Davis? I think we need to call it really a mediator
that sounds
slash
good. Okay.
facilitator, because if we go that route, then we can call it professional services and not go through competitive bidding. I can certainly I know a bunch of those type of folks, and we can certainly call them and I can vet them with you.
But I think no matter what you do, the sheriff is going to have to enforce it. So I mean,
I agree.
I'll modify my motion to say mediator in lieu of facilitator.
I'll second.
All right, is it Mr. Hudson? Come up, you gotta come up here.
3 motions on the floor.
We do.
I'm confused as to
Oh, well.
which one you're
Okay.
discussing.
We have a motion on the floor to hire a mediator this is the motion we're looking at now, to hire a mediator to help the customary use committee.
Correct. Chair.
Is that correct?
Yes.
Okay. Is that the motion we have on the floor and the second?
Yes.
All right, that's what we're just.
Say that again. I'm sorry. I'm sorry.
We have a motion on the floor by Mr. Chapman to hire a mediator to help the customary use committee and chairman with the customary use issues.
With the committee.
With the committee, right.
With committee.
Am I correct, Mr.?
That is correct.
Okay.
You've got 2 of them flagging down out there for some reason.
One at a
Somebody come
time.
up.
Bob, you're going to have to come up. I'm sorry.
There's 2 Bob there.
There are 2 Bobs. That Bob.
Bob B before Bob H. That sounds reasonable. Bob Brook. It seemed to me you already had an motion on the floor to give the administrator the right, so you're talking about the wrong, it seems to me you're taking them out of order.
That was how to select the committee. This is on the purpose.
Yeah, but I don't think that mission has been, I don't think that motion was acted on. You had a second, you had a motion and a second, but I don't think it was acted on.
Voted, Kim,
Yeah, we voted. Yeah,
it was voted,
we did.
Bob.
Yeah, we voted, yeah.
It was voted on.
Yeah, we did.
If she recorded it, we voted. Yes, we did.
Okay.
If Kim
Well-
says we did, we did. Trust me.
Okay. So now you're talking about I think, while I'm up here, I think Commissioner Jones's recommendation for mediator, facilitator, whatever you want, somebody in charge of this committee is an excellent idea. However, I still think you need some criteria for selection of the people on the, whether you have the administrator provide you with criteria or coordinate them one-on-one with you, but you don't have any criteria for making selections, or at least you haven't given you've given a bunch of verbal, but nothing's established.
Well, I made some suggestions,
Don't
but
you write things down?
I made some suggestions, but they said that Larry could handle it, and he was going to come back and put people in spots that we alluded to. That's how that went down.
But wouldn't you like him to come back and give you the criteria he's going to use?
I think that's an excellent idea. He should come back to the board, but I
agree. Excuse me, though. Sorry.
Thank you.
Thank
Mr.
you.
Hudson.
He ain't got no say.
Motion and second.
All right. Hey, did you say call for the question?
No, I didn't.
Oh, okay.
Lisa wants to.
Ms. Bausch.
Lisa Bausch,
We're listening to Ms.
BOUSHI.
Bausch.
Thank you. I just want to suggest that I think it's a good idea since you're aiming for criteria. I don't think you're going to have this committee really in place to do anything before January anyway. Why not go ahead and maybe you all send your suggestions for criteria? The only other thing I would suggest you do is once you've established that, I don't know how diligently people filled out applications with the idea that they were trying to meet certain criteria. You know, many of your committees, it'll say we want somebody that's in the bed tax business, we want somebody that's this or that, you know, and when you know those things, then you can let people know what your leanings are or what your abilities and so forth. Because I know, at least when I filled mine out, I certainly didn't fill it out with the idea that I was going to try to convince you, well, I actually have been in the rental business or that sort of thing. I just told you what I was interested in trying to help you accomplish. And I'm happy to serve, but I don't know that I put anything down that would be a criteria other than I've been a property owner for a long time and I now live here and I'd love to help. If that works out, see if we can't find a way to accomplish things peacefully. So anyway, that's all I would suggest. Thank you.
Mr. Jones, I will put you on the hot seat.
Yes, ma'am.
We could task you with coming up with either criteria and or committee names. Would you feel more comfortable if you came to us back and said, this is the criteria I'm going to use, do y'all agree? And then you make your selection once we agree to your criteria? How would you feel? I mean, because we're putting the burden on you, and it's a burden.
And what's unusual about that, man? and I love you. But just to answer your question and to address Ms. Bausch, what I would anticipate doing is tomorrow take the areas that have been mentioned and listed and submit them to those that have made application. And we'll know within 2 or 3 days who falls into what. So we can flesh that out fairly easily. So yes, we would look to capture some more and broader information on each of those.
From each of the 25?
So it's really up to you guys. I mean, we'll be glad to, look at those that fit into the different categories and make a recommendation, or put all of those that fit into the different categories and bring them back to you, and you can select from there. So we're good to
Yeah,
go.
we already did that.
Call the question.
All right.
The vote on the mediator.
Maybe on the vote on the mediator. On the mediator. We have a motion on the floor to hire a mediator. All those in favor? Aye.
Aye.
Okay.
And one more point for clarity.
Yes.
As mentioned earlier, we had 2 applications come in post the original deadline, and there was some discussion about accepting applications from northern portion of the county. Any desire to reopen and accept others, to consider these 2, or we'll go with the 24 that were there at the appropriate time?
Do we know if they're from the north end of the county or not?
I don't. The 2 new ones? hang on just a second, I'll tell you.
We have both in Santa Rosa Beach.
Yes, sir. Oh. Yes, correct.
Something. But if, if nobody's from North Walton wanted to be on it, I mean, maybe they don't want to be on it. I think we ought to stick with the number and then move forward.
Stick with what we've got. Okay, we'll stick with what we've got, and if you will come back to us at our next board meeting with the criteria and recommendations, and
Be
then we
glad to.
will either accept them, or we will continue to vet this issue. Where are we?
Number 20.
Number 20.
20.
Okay.
This is a request to authorize the staff to solicit bids on a property in Mossy Head near Sexton Road in New Harmony area. This is a parcel that we obtained title to in 2001 through a tax deed. It's about 1.25 acres. It is landlocked by other 1.25 acre parcels, if I recall. There's no access, no deeded access, no granted access. An adjoining property owner has asked for the ability to purchase that. So the request is, do you have interest in selling it and moving it? And if so, we'll work with legal to get the proper procedure in place to move forward.
May I also suggest, my book says there's an evaluation from Public Works attached. My book did not have any evaluation from Public Works. I just have a one-page. Others apparently have multi-pages. I have a one-page submission.
I've got the deed and the.
You must have got shortchanged, Commissioner. The bottom line is, it's 1.25 acres. It's vacant wooded parcel. It is uplands, but there's no wetlands, but it is no access or easement to the to the parcel, and no other county park properties adjoin it.
Yeah, it's kind of landlocked.
Okay. In doing a disposal, are we not required to go through a process where we advertise it for other people to bid on it?
Yes, sir. Depending on the property appraiser's value, there's a process for if it's less than 25 or if it's less than 15,000. Yes, sir. And the motion is to authorize us to start that process.
We need a motion for that.
And Mr. Caraway's at the door if you have any further questions from that standpoint.
Okay. I understand the motion, unless you want to go with that.
To start the process to make the determination.
Right.
And go through the process that's required in order to consider.
To authorize the sale.
Yep. I'll make that motion.
Okay.
Second.
Motion and second. Any more discussion on the board? Anyone in the audience? Seeing none, all those in favor? Aye. Motion carries. Next, we have Public Works. Public
All right.
Works, sir.
Yes, ma'am. Just make sure we're in the right place. Item number 21 is request to award and approve and authorize the chair to sign the construction contract 016-029 for the Western Lake Pedestrian Bridge Improvements Phase 2 to the lowest responsible bidder, which was C.W. Roberts, in the amount of $612,034. We recommend your approval.
Motion to approve.
And motion and second. Any discussion among the board?
No.
Anyone in the audience? Seeing none, all those in favor?
Aye.
Motion carries.
You can see the work going on now, so it's a beautiful sight, finally.
Next item is a request to select and begin negotiations with the top-ranked firm Walter Marine for RFP 016-012. This is for the Nerda Inshore Snorkel Reef Construction Project.
Motion to approve.
Second.
A motion and second. Any discussion?
Commissioners, I just have one thing to announce on that. We only had one respondent in this particular RFQ. We want to start negotiations with them. However, I'm sorry. Yeah, two. We do want to start negotiations with these folks. There is an issue with their insurance certificate. We think we have it cleared up. So please understand that if that does not get cleared up, we would come back and ask you for permission to negotiate with number two. But we think we have that resolved. I just want to let you know that.
I just have a point of order. Commissioner Chapman, did he leave?
He went.
Is he
He'll be
going
back.
for?
I am a recent, I've recently been made aware of the fact that as a commissioner, you can not leave the room and not vote on something. You have to vote on it.
Yeah, so we might want to have him come back.
We just wait. And everybody stare at him when he comes back through the door.
Yeah.
Yes, ma'am. You'll have to come to the podium, state your name, and spell your last name for the record. While we're waiting.
Julie Kelly, and it's Kelley.
Uh-huh.
I had a question on this, the upcoming that you're going to vote on, the nearshore offshore reef construction.
Uh-huh.
Do you know where that construction will take place? Will it be in the Gulf? And if so, do you know what area of the Gulf?
There's a map attached.
Yeah, there's a map on the, yeah. Up there.
There's the Gulf man that can tell you
Yeah.
a little more precisely.
Scott Caraway, Walton County Public Works. There's numerous permanent sites from Miramar all the way past Grayton. So these reefs will be in the nearshore, the snorkel reefs. There's 4 permanent areas, and there'll be about 254 modules scattered out across those 4 permanent areas. But it ranges all the way from Miramar past Grayton.
Yeah.
And we can provide you with a map if you would like.
Yeah. Okay. I'm curious if you can tell me if that will be similar to the snorkeling that's done in Destin where we go out across the pass, and if so, if that will also involve the location, the transfer of people from the shore out to these reefs on boats, and then after they get there, there's a process where they train people. They park all of the boats out there, and people are taking lessons on how to snorkel so that they can go into the reef.
I suppose people could do that. I mean, they're going to be open to
looking
the vote.
ahead before we have a line of boats and reef divers out, in front of Seagrove Beach or wherever.
Yeah, it's definitely a possibility that could happen.
We're kind of limited, though, where the boats, we only have, Grayton Beach that they can go out from.
Yeah.
Unless they come all the way from Destin, all the way to Seagrove, which takes a long time. So it won't be, couldn't be that many boats, I wouldn't think.
Because only so many can launch from Grayton, isn't that right? Yeah.
Right. Well, the way they do it in Destin, they come a great length from the Destin Bridge and around through the Destin Pass, and then park along there. So I think it would be very possible for them to do that.
Well, that may be something that we'll have to look into as we progress with this. Okay.
Just a concern. Thank you.
Thank you. Yes, ma'am.
I think we have to
All
go
right,
back.
we are back now.
We have to go back to 21 and let him vote on that.
Yes. We have a motion on the floor to authorize we have to, didn't you vote on 21? No? Okay.
Wasn't here.
Oh, okay. So we will go back and.
You want to do 22 now? Vote on 22?
Yes, we're voting on 22. Y'all are getting me upset today. We have a motion on the floor to select and begin negotiations with the Top Rack Company, Walter Marine, for the NERDA inshore snorkeling reef construction. All those in favor? Aye. All right, motion carries. Next, Mr. Jones.
There's a request to select and begin negotiations with the top-ranked company, again, Walter Marine, for RFP 016-035. This is for another NERDA, nearshore offshore reef construction in Module A.
Motion to approve.
Same condition.
Yeah, it's the same issue.
Same issue would apply.
On the next two
Yes,
as well.
ma'am.
We have a motion. Do I have a second?
Second.
We have a motion and second. Any discussion? All those in favor? Aye.
This request is identical to the last request, only this is Module B. So this is to select and begin negotiations with the top-ranked firm, Walter Marine, for RFP 016036, Walton County and NERDA, nearshore offshore reef construction, Module B.
Motion to approve.
Second.
A motion and second. Any discussion? Seeing none, all those in favor? Aye. Motion carries.
The last item is a request to select and begin negotiations with the top-ranked company, Walter Marine, for RFP 016-013 Walton County NERDA Nearshore Offshore Reconstruction Module C.
Motion to approve.
Second.
We have motion and second. Any further discussion? Seeing none, all those in favor? Aye. All right. At this time, we're going to take,
Now we need to go back to 21 and let him vote.
oh, he's got to vote on 21.
According to Commissioner Meadows, a commissioner has to vote on every issue.
I'm
If
just
you're
trying to
present.
no,
I
I'm-
wasn't present
no,
here,
no,
and
I'm-
if you're gonna bring that up, Ms. Meadows, there's been many a time this board had met, and there were still items to be taken action on, that you picked up your
No,
stuff and you
no,
left.
no,
So
I'm
don't
trying
even
to-
go there.
Ladies and gentlemen, time out.
No, I'm trying to save you from an ethics complaint here because, but I'm really trying to do you a favor. What they told me was that you have to vote on an issue. You can't leave the room or go to the bathroom or something. Now, you can leave the meeting or you can be absent from the meeting if you have, if you have a reason, you have to leave the meeting.
Just
But-
so you know, we were told essentially, I've just recently been told the exact same thing. You can leave
Yeah.
and be gone and not come back and participate in the meeting.
Right.
And that's fine.
But-
But if you leave and come back, that's the issue. So-
I'm trying to save you
I'll
a,
take a vote.
Yeah, so what I would suggest is we vote a second time and allow them to vote on the issue.
I'm trying to save you from the same shame that I've been accused
Okay.
of.
Well, we'll go back to number 21, request award and approve the authorize the chairman to sign construction contract number 016-029 for Western Lake Pedestrian Bridge Improvements Phase 2 with the lowest responsible bidder, C.W. Roberts Incorporated, in the amount of $612,034. We have a motion
Motion again.
by
Cecilia.
and a second. We have all those in favor? Aye. Very good. We're going to take a 10-minute break, so we're all will. Where's Mr. Tusa?
Sitting right there.
Oh, there he is. Mr. Tusa, we are ready for you, sir.
Good evening, Madam Chair, Commissioners. We just have a couple of agenda items this evening. First up, item 26, request approval to move property review from the November 22nd BCC meeting to the second BCC meeting in December. And this is up to you, but I don't think when we scheduled the meeting for the November 22nd that we realized that we would be seating 2 new commissioners and going through the committee process, appointing the new, electing the new chair, vice chair, and so on. And from what I understand, I'm new to this process, so that takes a little bit of time. So I didn't know if y'all wanted to keep the review of properties on the agenda for that evening, or if you wanted to move it to a subsequent later date. So,
I'll ask the three, what do you think?
I say move to later date.
Later date.
Okay, move to the 13th. Do we need a motion for that, Mr. Davis? Okay, gotta have a motion,
So
please.
moved.
Second.
Motion and a second to move the, where are we? To move the properties review from November the 22nd to December the 13th at, during the regular meeting, or do we?
This is the second BCC meeting in December. Usually there isn't one, is there?
well,
It's
that's,
the 27th.
and that's, we have one scheduled, but I think that was a, the meetings are usually kept short, so that's why I wanted
Yeah,
to
that's
ask
the
about
20
that. So, we can do it at the December 13th meeting, but I believe that meeting is a,
That's a Tuesday.
yeah.
Of course it's a Tuesday.
Yeah.
Of course, there, Catherine, it's a Tuesday. 3 weeks after they take office?
Yeah,
I
so
think 3 weeks would give them
that's
enough
enough
time
time.
to
I mean,
review.
I can certainly get with the new commissioners and bring them up to speed,
Okay.
and I don't mind doing that. So if you want to do it on that date, we can.
Do you want to do it on?
December
the-
13th?
The 13th?
I'm fine with that.
Is that your motion? Okay. Do we want to do it at 3 o'clock? Start an hour early, just to have time to review them all?
We got what, 19 or more?
No, actually we have 40. But they're grouped together, so I think it's a total of kind of like 11 projects. So it shouldn't take too long. I think an hour would be sufficient.
And it's not like we have all the money in the world to spend.
We don't.
We're limited, so.
We don't. Actually, I was going to mention that in just a second when we
So
through
you want to
this.
do it at 3 o'clock? Is that
3 o'clock's fine.
in your motion? Okay. We have a motion and a second to review the properties on December the 13th, beginning at 3 o'clock down here at the South Walton Annex. Is there anyone that would like to speak to that issue? Seeing none, all those in favor? Aye. Motion carries.
Thank you, Commissioners. And just a question regarding the properties. I've been approached by a few realtors, by I guess about 4 parcels, and they wanted to see if you would consider them to be included in this December 13th. I think we're getting a little close at this point, but that's totally up to you if y'all want to add additional properties. We have a parcel in Hogtown Bayou, Eastern Lake, Little Redfish, and Dune Island. So,
Is that one in Little Redfish? Gosh, is that one in Little Redfish? Is that the one on the outfall, the 30-acre piece on the outfall?
It is.
That's that one? Okay. That's the one that they came to me about. So good. I'm glad you're handling that.
yeah, they did get in touch with me, and that's why I'm asking if y'all want to include that into the mix of the other properties, or if you want to leave that for a later date.
How many do you say we have right now? 40?
Yes, ma'am.
Let's just look at all of them.
Okay, so you'd like
Throw
to
them
add
all in
those
there.
as well? Okay.
Okay.
Is that
Need
good
a
for you,
motion
Mark?
for that, Mr. Davis? Okay, give me a motion, please.
So move.
Second.
Motion and second, all those in favor? Aye. Throw them in, Mr.
All right, I will add those. Then let's see. The next item, request to approve the addition of 2 full-time beach ambassadors to TDC staff. At the last meeting, it was asked if we had what we felt all the resources in the way of beach ambassadors. And Brian and I got together, and we are in need, we think, of 2 more full-time beach ambassadors. And the positions we have in the budget, and the salaries are $27,331 for those 2 positions. And Commissioner Jones had asked me a few days ago when we were speaking, as far as what would these 2 staffers do in the off-season. And Brian and I spoke about that, and we think that we can utilize these folks probably through about October on the beach, because our beach is still fairly populated through October. And then at that point, we can pull them in and get them to help our visitor services folks and get out and really interact with our bed tax collectors, getting materials out there, informational pieces on, the different etiquettes for the beach, if you will. So that's what they'll be doing in the off-season. And they'll be also assisting code enforcement.
Would these people be on the beach, like what, 8 hours a day, or what?
Yes,
How
ma'am.
does that work? And are they in a car? Are they? I mean, a truck? Are they walking? Or what?
They walk, and we also have a little vehicle that they can use and share.
Okay.
And we have four-wheelers as well that they can utilize.
Okay. Okay.
Motion to approve.
Second.
I have a motion and second. Any more discussion? Anyone in the audience? Seeing none, all those in favor? Aye. Motion carries.
Thank you. And just a quick update, we got our September numbers in, and they were down a little bit, down 1.8%, for a total of $1,897,584.19. And I think the reason why we're down a little bit, I talked to some of our larger bed tax collectors, and when we had the hurricane, the storm for Labor Day weekend, that was probably about $750,000 or $1 million worth of losses for some of our hotels and bed tax collectors.
Is that 1.8% down from last year?
From last
Same
year,
month?
year over
Okay.
year, correct.
Same month, okay.
Correct. Yeah,
Okay.
and then for year over year, though, we're up almost 8% to a total of $21,754,913.12. So we finished the year up almost 8%. So I think that's good. And unfortunately, there's not much we can do about Mother Nature.
So how many visitors did we have last year?
We had 3.6 million, up over 3.2 from the prior year.
Wow, up from 3, so another almost half a million people
Correct.
came last. Okay, thanks.
Yes, ma'am. Any questions?
Thank you.
Great, thank you.
Thank you, Thank you, Commissioners. Just a couple items. The first is a request to approve an updated resolution for county parks and facilities and a fee schedule. Essentially, Commissioners, we are asking you to add a deposit and fee for use of the library by for-profit groups. It was left out of the previous resolution.
For-profit, what?
For-profit groups to use the library, the Coastal Branch Inn.
To use them, what kind of fee is it?
I think it's $50
$50.
for first 4 hours, and
Okay.
I have to go back and look. 25 for less for first 4 hours, 50 and more for the next 4 hours.
Well, I hate to see our people have to pay to use a room because we don't have that many rooms. So I never like to make them pay for using the room. I mean, maybe cleaning up and things like that, but I think $50 is.
Now, it's refundable if under some
If they clean, it's a refundable.
It's a refundable maintenance deposit.
Okay, it's a deposit, not a fee.
Right. Oh, I'm sorry. No, I'm wrong.
Okay.
It's actually a fee.
Fee, okay.
Well,
But
Yeah,
if
I'm
it's
not
going
in
to be
favor
for
of
more than 4 hours, we're going to take 25 as a refundable deposit.
I'm not in favor of that, so.
well, I guess my only concern is, yes, a lot of these people, and I have seen it, especially at the library, walk in, use it, and walk out. And it's for somebody else to clean up, to vacuum, to stack the chairs, to do all that kind of thing. If people would, you know.
But that could be a deposit
up.
and then they don't get it back.
You know.
And also, just so you know, the use facilities policy that we have requires us to have a distinction and a fee for for-profit use versus no fee for not-for-profit use. So just so you know, we're just trying to follow that policy.
Mm-hmm. Okay. All right, what's your pleasure, ladies and gentlemen?
Motion to approve.
Second.
I have a motion on the floor to approve this change in fees. Is there any discussion? Anyone in the audience? Seeing none, all those in favor? Aye.
Nay.
Nay? Okay. Next, Mr. Davis.
Actually, I'm subbed in. The next agenda item, this is very similar to the agenda item that you guys looked at under admin. The county owns a parcel in Oakwood Lakes Estates. One of the neighboring property owners would like to purchase that from the county. So what we're asking you to do is authorize staff to solicit bids for this county-owned parcel. And what that would entail is us just sending out notice to all of the neighboring property owners. We collect those bids and then bring them back to you to make the final decision to either accept them or reject all of them.
Why wouldn't you open it to the general public?
For parcels or for properties that are county-owned that are valued at $15,000 or less, the county can decide just to solicit it to neighboring property owners. And this particular piece of property is on the plat. It's identified as a green space, so it can never be developed in any way. And the person who wants to buy it is aware of that fact. He just wants a bigger yard. So what I would suggest if you do end up selling it to this individual is we just put a restriction in the deed that clarifies that he can't develop the property.
But if it's already green space and the county has it,
Yes, sir. This item actually came before the board back in February, and the direction from the board was a little bit unclear. That's actually not the piece of property. I'm not sure what property that is. But so I'm just bringing it back before the board. The individual, his name's Mr. Eckhart. He contacted my office and asked if the county was still interested in selling it to him. So that's why I'm bringing it back. The direction in February wasn't clear.
I guess this would give him the opportunity if
That's
he
the
wanted to plant flowers on it, if he wanted to plant trees. As long as he owns the county, he probably can't do anything with it. He probably can't mow it. You know, it might be getting, but if he can't develop it, but yet he could still enhance the property with landscaping, I would think. Am I right?
Yes, ma'am.
which is his property?
His property is, I guess it's the narrow part. It's to the north of the very narrow part. Yes. His name's Mr. Eckhart.
Okay, he owns that and he wants that piece.
Yes.
Okay.
So we would actually send out notice, though, to every person who neighbors our property and collect bids from them.
Oh, okay, so you would give them a chance as well.
Yes, ma'am. And the property is valued on the property appraiser's website, I believe, at $3,000 or $4,000.
I'll buy it.
I think we should put it out.
Are you limiting the bidding solely to the people in the immediate area?
Yes, sir,
So
but
if
if
somebody out there heard about it tonight, they could,
if you would rather, we could open the bids to, we could advertise for bids from anyone, if that's what you would
even
prefer.
though it's restricted to solely green space,
Yeah.
that
Yes.
particular lot.
So exactly who would want to buy it and then pay taxes on something they couldn't use? But there could be somebody out there.
They could buy it and donate it for tax reasons.
That's true.
So I guess we would ask for direction either to solicit bids from the open public, from anyone, or from the neighboring property owners.
That's if you want to sell it.
Yes, sir.
I would solicit bids from the neighboring property owners because.
But I guess we do need a motion.
So moved.
To the neighboring property owner. Second.
A motion second to offer it to the neighboring property owners. Any further discussion?
Unless Bill Infeld wants it, and then he could bid on it.
Anyone in the audience want to comment? Seeing none, all those in favor? Aye. All right, motion carries.
Thank you, Commissioners, and I guess I'll just handle the next item as well. This is a request to authorize staff to begin the process of changing the land use designation from neighborhood infill to public facilities for the property that was purchased in June Allen. It's on the screen. As you may know, since the property's neighborhood infill, it would require a major development prior to any development of the property. But if we change it to public facilities, we can go through a minor development process.
Okay. What's your pleasure, ladies?
Motion to approve.
Second.
A motion and second, any discussion? Anyone in the audience? Seeing none, all those in favor? Aye. Motion carries. Thank you. Commissioner Meadows.
Yes, I would like to bring up the Headland Beach access issue again. It's been 6 months since it was denied. But first, before that, I would like to say that it has been an honor and a privilege to serve as your District 5 Commissioner. And I've enjoyed it immensely, learned a lot, and I'm looking very forward to being a private citizen. So thank you all. And I'll move on to the Headland Beach access, which will be my last item under my name. I would like you to think of this as this is this is Walton County's public beaches heritage, and I'm hoping that we don't look at it as this guy wants it, this guy doesn't, this guy across the street. We're not. That's not what this is about. This is about providing access to the public, as many accesses as we can possibly get. They say you can never be too skinny or too rich. My thinking is you can never have too many public beach accesses. You can never have too much public beach. And one of the gentlemen said, let's move on to more important matters. I don't think there's anything more important than our heritage here in Walton County, than our citizens, both north and south of the bay, back decades, coming to the beach, having a great time with your grandkids and your families, and creating some beautiful memories. In that this seaside was actually platted copying these old plats, just like this one, where all the roadways, if you notice, end in an access to the beach, because it makes all the properties to the north, and Robert Davis was a genius in this, is that he saw it. It makes every property have access to the beach, even if you're in the back row. You can walk down the roadway and go to the beach. So this, with TDC's numbers, up 8%, another almost 500,000 people coming to the beaches, $21 million worth of revenue, 3.6 million people coming to the beaches. You're going to need, I think, every square inch, every square foot, every access that you can possibly imagine. Now, I know that surrounding people, we've seen that, they don't want even a hose bid. They don't want an access. They don't want to walk over. We saw it on Bullard. They don't want people, streaming down there, or they don't want people parking or what have you. This is a walk to, bike to, beach access that is the very similar to all the ones along there. And the Florida statute actually states that when an access is taken away, like the one that was when the Seagrove Villa Motel was taken away and the access there, public access was taken away, that the developer has to provide a like-kind access very close to very similar. Well, we've got an access right there, and it's to a public beach. So, that is why I would like us to look at this as this board being the board that said, enough already, we're getting people to the beach, we want them to be able to get there, we want them to be able to sit on the beach, this is the board that did that. And if previous boards had done that, I don't think we would be in the situation that we're in today. But for people who have lived here and come to these beaches and lived in these neighborhoods around here since the 40s and 50s, I don't want to see people coming in and building houses next to them and then saying, no, we don't, it's too unsafe to build an access there. If that was the case, we would never have an access. So what I would like to do is say that when you look at the survey of this access, you see that there is actually a boardwalk, a walkover on it. So you've got to decide how you're going to deal with that. It's on public property, it's the access, it's the boardwalk from the neighbor's house. You've also got encroachments in the right-of-way, which I understand the Public Works has tried to contact the family to the west and get a right-of-way agreement executed so that in the event that the county needs that space for anything other than what it's being used for today, that we have the right to go in and use it. Now, the county's already provided drainage there, so the drainage issue has been taken care of. This is simply an issue of opening up a 5-foot pathway and building a walkover down to the beach, and that is basically it. That's why I wanted to bring this up. As a resident here for almost 20 years, I hate to see this kind of thing happen. And once it starts happening, we're approaching where more people will want it the same. Nothing near my house, nothing across the street from where I have a business or what have you. So, like I said again, this is not about who's for it, who's against it, and this, that, and the other. It's just the fact that the public, if we're going to spend millions of dollars going after customary use, why wouldn't we open up a public access with a public beach that could very easily be a walk to, bike to access? So I will open it to, there's a couple people in the audience I think that probably want to speak, so I will end my presentation at that point.
Well, I will pick up where you left off. I don't know the people involved, so I'm like you said, I have no personalities here. I mean, I recognize them when they come in, but we are looking at, in the near future, spending millions of dollars on beach access. I think we need to look at every beach access we have, no matter how small it is, and try to utilize it in some way. If this is a dangerous intersection or whatever, certainly walking there or bicycles there and no parking. I think we should look at that. But I think we set a precedent, and a dangerous one, if we allow the homeowner next door to take this over. Maybe we haven't used it in 20 years. And then what happens to the one down the road and the one down the road? No matter how small the access, even if it's just, as you say, just to walk down to the beach, at least the county has that, and people that live there can walk. I do remember when people used to walk to the beach. So I am inclined to agree with you. I think we need to take a look at every beach access that we have and see how we can utilize it in some kind of way. Maybe we can't put in a regional access, that's fine, but put in a beach walkover and a couple of trash cans. is my suggestion, but I will, is there anyone else on the board that would like to say something before I open it to the public? Seeing none, I will open it to discussion to the public at this time. Would anyone like to speak? Yes, sir. Mr. Morris, if you'd come forward, state your name and spell it for the record.
Thank you, Commissioner. I'm Hugh Marsh, M-A-R-S-E. Headlands Avenue is a 4-block road in the Sea Highlands subdivision. There is no doubt on the plat that it's designated as a road, and there is no doubt in the county that the county has accepted that as a road. In fact, there's a memo on file by a legal attorney that was hired by Walton County says the county has accepted those roads and parks. Now, the southern end of the road is Gulf Front and is connected to a county-owned beach. To the best of my knowledge, Sea Highland has never been abandoned in accordance with the Land Development Code requirements, not any portion of it. And I've been a property owner in Sea Highlands for 54 years. I'm confounded by the county's position to allow 2 abutting property owners to absorb the last block of Sea Highlands subdivision as part of their landscape yard. At the 27th September County Commissioner meeting, Commissioner Meadows requested Walton County Road Department to clear the vegetation on the southern 150 feet of Headland Avenue. Last week, I called the Walton County Public Works and was told that they had no intentions of clearing that vegetation on that road, that they were going to sign a road right-of-way agreement and leave the vegetation there, thus giving exclusive use of a 20 by 150 foot portion of a road to 2 abutting property owners. TDC has proposed building a public walkover at Headlands. The beach walkover will be built using TDC funds. There would be no county funds required. Building a beach walkover on a county-owned property leading to a county-owned beach at no expense to the taxpayers seemed like a no-brainer to me. With Walton County aggressively going after new beach accesses and giving away a 20-foot by 150-foot parcel of land that goes down to the beach just doesn't seem smart. The county recently spent $6.5 million to purchase property for a beach access. At that price, they paid $30,000 per front foot. So the Sea Highlands Avenue that's been absorbed by 2 abutting property owners is worth $600,000. Why would the county effectively give away a $600,000 piece of beachfront property when it can be used better by the public?
Thank you, sir. Anyone else? The gentleman in you want to go next, sir? No, he go. One of you, come on.
Good evening. My name's Jeff Herrig, H-E-R-I-G, property owner in the end of Headland. My property actually is immediately adjacent to Headland Avenue on the north side. I want to thank you, Chairman Commander and Vice Chairman Jones and fellow commissioners. I'm here to ask you to follow your TDC's recommendation and vote in favor of constructing a beach walkover on the publicly owned property at South Headland Avenue. If that request is a bridge too far, no pun intended, I would request that at minimum, you would vote today to require all encroachments and structures illegally constructed on the people's land at South Headland Avenue be removed immediately. We know that you often deal with difficult, complex issues, but frankly, this is not one of them. I believe it's as simple as this. Some 60,000 citizens of Walton County and countless guests would like to walk across their property to access their beach. It's a shame that 2 property owners on either side of the public property have had great sway in this issue. even to the point of one owner building an illegal walkway to the beach and another owner apparently ignoring building setback requirements. But let's be clear, opening the public beach walkover will have zero impact on these owners. People will walk on public property next to these two homes just like they do now in front of these two homes. When I was a special agent for 14 years with the Florida Department of Law Enforcement, our commissioner had a standard response to any question about how we should handle ethical dilemmas. I often heard him say, FDLE will not do anything that we can't stand on the steps of the Capitol building and shout to the people. When you consider this request today, I hope you find his example helpful. I also hope you will grant this request on behalf of your colleague, Ms. Cindy Meadows, who has served the people of this county so tirelessly. I would hope that when your service on the board ends, your colleagues would grant you the same consideration. We are counting on you to assert the people's public ownership of this beach access. If you can't afford to build a walkover now, that's okay. Maybe put it in the next budget. I understand the money is available already, though. At a minimum, though, however, I would ask you to immediately and unmistakably clear these private encroachments and as soon as possible thereafter build a beach walkover that will accommodate many happy tourists and neighborhood homeowners. With the beach walkover in place, we will once again demonstrate our county's reputation as being the most warm and welcoming family destination in Florida. Thank you so much.
Thank you, sir. Yes, sir. Come forward, please.
Hi, Tim Wilbanks, Wilbanks. I live adjacent property there at 12 South Headland Avenue. I wanted it to be known that I have talked to Public Works Department as well as the Code Enforcement Department and asked both if I needed to remove any vegetation that we put there, our landscaper put there when we built our house. They both said absolutely not, that it helps with erosion control, and that they only wanted me to sign a letter saying that if the county ever needed that for anything, I would remove the vegetation, and I have since filed that with the both departments, so they do have that on record. Also, I keep hearing about the my house being encroaching on the setbacks, and that is, I've sent you guys a package today that shows that we are in compliance. We are heated and cooled spaces at a minimum of 7 foot 6 inches from the line. What these people see is a wall, a privacy wall, that's within 1.5 feet of the line, which is allowed, and it's allowed up and down the beach. That's part of the code enforcement. This is signed, sealed, and delivered. The county's approved it, so there are no setback violations, and everything was signed off by the county. Thank you.
Thank you, Mr. Wilbanks. Yes, sir. And then, okay, them, and then, sir, you'll be next, the gentleman in the blue shirt.
Mansell White, Montgomery Street. There's been a lot of inflammatory and false statements been made here tonight about this issue. I've lived and grown up in this area all my life. I'm 66 years old. My parents bought the property next to this piece of property under contention right now in 1951. And I know what's going on there. It's never been an access before. The assertion that there's a structure that's encroaching on there that needs to be removed is just a lot of baloney. There's a step that my nephew built there that was permitted by the county and by the DEP. Every one of the structures, the beach walkovers all up and down that beach in Seagrove and Sea Highland are all on the public park. Every private step or step in front of every house is actually on the bluff, which everybody acknowledges belongs to the county. So if you say that if somebody tries to say that this particular step needs to be removed, you'd have to remove every step all up and down the beach wherever there's a public beach. It's just not true. I mean, the county has permitted that step as well as the DEP. So it's just ridiculous to keep these things. People talk about how They're rebuilding an existing access. There's never been an access there, never once in the history, ever. And no access was lost either. The one for the people used the Flowers Motel in the old days on an ad hoc basis because the Flowers just didn't chase them away. That was a private access. They had to trespass on the Flowers property in order to use that. When that went away, when they built the 4 houses there, that was not a lost public access. That was just a lost trespassing access is all it was. Now, I agree with Commissioner Meadows about we need more accesses, and we definitely do. We got miles and miles and miles of 38 with absolutely no access whatsoever, and yet they want to cram another access on a 3-block street where there's already 3 accesses there now that are publicly maintained, plus the ad hoc access that was talked about earlier in the discussion about the quiet title. That access is going to stay there. So there's 4 accesses on the street already in a 3-block street. This was a quiet neighborhood I grew up in. You keep putting these accesses in there, and it's going to change the nature of everything for the whole neighborhood. And people are going to be, we already got a problem with people coming in from miles around with golf carts and parking on lawns and everything else to use the beach just because it's there. We don't have a dearth of access. We have the most rich environment of access on Montgomery Street than anywhere else on 38. We don't need another one. Spend the money where it's needed, where they have miles and miles and miles of no access on the beach. Thank you.
Yes, sir. I'm sorry, the gentleman with the blue shirt's next, ma'am.
Thank you. Dale Koblenzer, Koblenzer. I also live on Montgomery Street. It's been in my family, or my wife's family, since 1953. I want to bring up 3 issues. I think first one of safety, the second one of fiscal responsibility and those accesses, and the third one about the heritage we spoke of. I do want to sort of talk about what has been true as far as I know. First of all, safety. The use of Montgomery Street has never been a big major thoroughfare, but it has changed since I've lived on that street. It has now become sort of a respite for people to get off of 30A. They push their baby strollers, they ride their bikes, they stroll, and they line up on that street continuously at busy times. They come traveling east to west, and they turn up Headland, and they get out to 30A. My child has been hit on a bicycle there. I have been hit on 30A there, and there is a constant safety. That is a blind corner. There's nothing you can do about it. It's not like Greenwood, where you can see when people come down. It is a safety issue. In late 1990s, the beach was set on fire by some people using the beach and smoking on the walkways. The fire department could not get down Headland, and they could not get to service that fire. It is not an easy corner. It is never going to be an easy corner. Second of all, as is spoken, fiscal responsibility of using these taxpayers' money. Has anybody really sort of studied to see how many people would use this access? There are 2 of them within 300 feet. It's not a big inconvenience to walk to either one of them that are already there, and the use of several hundreds of thousands of dollars to build it and maintain it when there's so many other needs in this county does not necessarily seem as something that might need to be considered. Okay, I heard today that there was access there. There has never been access there. There used to be a hot tub on the top of that spot that you would rent when you use Cottage A. There was never steps there. My family had used that motel many times for that, and I do them. So that heritage of a bringing back a use is not a true story. Thank you.
As far as being a heritage, I never said it was I always said it was a road there. So just because there was never an access there, we have a lot of those places. We're building new accesses, so that's not part of my...
All right, ma'am, go ahead, state your name again. You spoke earlier. Speak your name.
Julie Allen, Allen. So my family has owned a home there since the 70s, and we were good friends with the Flowers. For clarification, Headland was a road that went all the way to the bluff, and it's platted as a county road that goes all the way to the bluff. We would walk all the way to Headland, down to Cottage 1, and then walk across on cement blocks and access the stairs. And if the county commissioners would go back and look at the TDC records, at some point through hurricane damage of other walkovers, the TDC did start the county did start taking care of those steps in some way. They added a flag, they added garbage cans, and they helped maintain it, and the flowers would let people use that as an access to the beach, to the public beach. So that is been verified with county people in the records. Y'all said to please ask Mr. Hall questions while he was here and spoke earlier. So he helped clarify that the county has accepted and improved other county roads within Sea Highland. For example, Greenwood and Andalusia. So the president has been said that all these county roads should be accepted within this platted community. And if one road has been improved upon, then all of them should be improved upon and maintained. And the county lawyer, the attorney, has spoken that y'all always have an interest and commitment to preserving the public's access to the beach. And that's what we're asking. If you do nothing and let it sit there, it's already been demonstrated that these neighbors, they feel like they're above the laws or the regulations. And they just take it and consume more and consume more. When the villas were taken down or demolished, the road maybe was broken or not a very good paved road, but it was there. Now, since the new house has been built, the road has a curve in it and has been changed. And I sent you pictures of all that in July of this past year from when we were down there, and just surprised at all the changes and who is monitoring all these changes of a county road, that it could come in and be repaved and added a curve to it. Now, I know everybody has talked about safety, but what is the difference if you have to cross 30A at one point? What is the difference of crossing it at another point?
Okay.
As long as you're crossing 30A, you're crossing 30A.
Right, thank you.
So thank you, and I want to thank you all for your time and your volunteering and for doing all this and listening to everybody's issues. We really appreciate it. Thank you.
Ma'am. Anyone else?
My name is Tom Heidel, Hidell, and I live in Sea Highlands, live on Montgomery Street. Don't live on the Gulf, live on the north side of Montgomery. Use the Greenwood walkover. And Cindy, we don't have any, or Commissioner Meadows, I don't have any problem with people going to the beach and having beach access. I think that's why we're here. And I don't think there's anybody on Montgomery Street that is trying to prevent people from having beach access. And when you go from 395 to Dothan Street, there are more beach walkovers there than anywhere else on 30A. There's one every 4 houses or 5 houses max. Think about that. Every 4 or 5 houses. This beach walkover on Headland, or the one that we're talking about tonight, there are only 6 homes that are closer to Headland than they are to the existing beach walkovers. 6 homes. 4 of those homeowners do not want the beach walkover put there. And the reason they don't is strictly a safety issue. I don't know how many of you have driven down either Headland Avenue or walk or ride your bike or drive down Montgomery and turn on Headland. It is as dangerous an intersection as there is in Walton County. And there is no room for parking. The only thing that you could do there is walk or ride a bike. But you're talking about building an access point that services basically 2 homes that are in Sea Highlands. And all the people from Sugarwood, with the exception of one person, they use the Greenwood walkover. Anyone else would have to be trespassing through Sea Highlands to get to the Headland walkover. And I think I went to the last meeting that you all had in Defuniak Springs, and there was a lot of time spent there, just as there was today, about the county acquiring property to provide beach and bay access. And I think that is critically important. And I think that the money that you have, and we all have limited funds, should be spent in a way that it serves the broadest number of people that we can, that provides ADA access, provides safe access to a large number of people. And that is not going to be accomplished at Headland Avenue. Thank you very much.
All right. Is there anyone else? Yes, ma'am.
My name is Alice Butela, B-U-T-E-L-A, and I am so glad to hear that the people on Montgomery Street really are not preventing anyone from using this beach access. Wow, that's really interesting. Because, anyway, they are, whether they like it or not. But I want to thank you once again for giving me the opportunity to express my opinion on this critical issue, and it has to do with the obstruction and the taking of the public beach access. Yes, there may have never been a wooden beach access for the public there, but this is a platted beach access. There's a big difference. It's there to be improved, and that's what we are asking. We're not saying replace what was there before. That's not the issue. And I also thank the county for surveying this property, because this survey clearly shows in black and white what has happened to this access. It is now clear why these Gulffront owners would speak against the improvements to this area that would give their neighbors easier access to the beach down Headland, and thus taking pressure off from the Greenwood access, which is very, very crowded, as you've seen. And that is that two owners have apparently decided to take this access for themselves. Now, wouldn't that be nice for you and I if we were able to just expand our yards 20 feet and build whatever we wanted there? Especially if it was Gulffront property at $500,000 or more, and you wouldn't even have to pay tax on it because it belongs to the county. Now, we all have right to make suggestions here regarding the use of county property, but we definitely do not have the right to obstruct the public from using county property and making it their own. And this is what occurred, and this is what must be righted. This 20-foot extension is not someone's property as the planning and the irrigation have made it appear. Headland Avenue is a platted public road with public beach accessing hundreds of feet of public beach. And it needs to be restored so unusable for all the neighbors. And what alarms me is because property has been taken already from the people, and that is demonstrated by what Whiskey Bravo has done to North Headland Avenue. So I would ask today that you vote on this to restore this back to the county as it belongs, and to let Commissioner Meadows suggested 5 feet to walk there to the beach. And yes, we do need it. One house, 20 people at least, and that is on Birmingham, and they can fill up Greenwood pretty quickly. Thank you.
Is there anyone else? Mr. Butela.
At the July 12th workshop, a representative of the fire department stated the Headland had better fire truck access than most of Montgomery Street. If fire truck access and safety are legitimate concerns of people on Montgomery Street, the county should consider widening Montgomery Street, including a sidewalk. There's 40 feet of right-of-way there for the county to use. As I had showed previously on this map, there's a lot of unused right-of-way that could make that road safer. And as I pointed out before, this is actually a safer access than most Seagrove accesses. It opens onto a neighborhood street and not on to a highway. There are many new houses, large houses, that have been built down on Old Seagrove Drive. They actually access our area, beach accesses, by coming up a small corridor along the west border of Sugarwood Beach, which is actually in line with, actually shows on that one display, actually lines up with Headland, and I've seen people walking up from there. And those houses are large. Many of those will hold more than 20 people and will fill access all on their own. Headland is the only access between Sea Highland and Seaside that has room for bicycle racks and a shower. The other accesses, which Old Seagrove has to use, are only 5 feet wide, very narrow, no place for a bike rack, no place for a shower. They would much appreciate to have this access, which is 20 feet wide. In regards to what Whiskey Bravo said, it's quite disturbing and hypocritical for them to be complaining about the public taking their parking. They're the ones that take public parking on 30A for use of their patrons and staff, and have also cleared and North Headland for parking for staff and patrons. So, and plus the fact the fact that Whiskey Bravo has problems patrolling their parking is not justification to deny a public beach access. The owner of North Headland says it's unsafe for pedestrians. Well, if it is, it's because they are using North Headland as an entrance for their parking lot.
Thank you. Is there anyone else? Okay. We will direct it back to the board for further discussion. I would like to support Commissioner Meadows tonight, and because I have had some concerns over, this is public access, we need to use it. There've been a number of questions raised tonight about the road, and has it been altered, and has it been turned, and that sort of thing. I'm not so sure that I don't need some more discussion with Public Works, but that's just me. Board members, what?
Well, go ahead. I'm sorry, Bill.
Yeah, Mr. Chapman.
Madam Chair, I did a site visit down there, and I did observe the vegetation that is from Montgomery Street to the beach. I'm glad to hear tonight that the owners have agreed or have signed the necessary paperwork with the county in the event that we wanted to go in there and use it, which we should have. It shouldn't have never been there, in my opinion, in the first place. It went over on the wrong side of the line. But then again, I have done a site visit. If there's 40 feet on Montgomery, then I'm thinking, from what I can see out there, and I don't have a survey that shows it from the county, there are a lot of vegetation and other things that have encroached on the right-of-way. Now, if we take a position to start removing all this stuff, we're going to have a massive fight on our hand, because for years and probably decades from previous boards, nobody said anything. It was allowed to continue. And so we've got those things to deal with. That is a bad curve and a low visibility point when you're coming down Montgomery, going to turn on Headland. And my concern is the safety issue. Now, I know they might be biking and all that, but we've already heard there's been accidents there with bicyclists, and it is real narrow in there as you approach from the east to Headland. What I noticed the day I was out there was several vehicles that were parked in the right-of-way. And just to the east of where I seen them, there was a sign saying no parking. But we can't go out there and cite anybody. We can't make an arrest or whatever the case may be. We have got to employ our sheriff's office to go out there when we post these signs for no parking to do something about it. We can't. All we can do is regulate it with signage. Now, if there's some way that that intersection can be designed that would take the safety issues that I have in my mind concerning it, then I might be more willing to support putting this breezeway, or not breezeway, but walkway back down to the beach. But I really do have, based upon my law enforcement experience, have some major safety concerns with that intersection.
You could make it a T intersection for sure. And you could, and it'll be like every other T intersection. If you're riding bikes out there and you're walking out there, there's not an access way there now, and you've got tons of bicycles and tons of people walking out there now. So if there's a safety issue out there now, then it's just because people are walking and biking everywhere, all over that area. So there's not one section that's more unsafe than the other. There are hundreds of people coming and going. If they're going to Greenwood, they may come that way. So, I think we hear all kinds of things that people say as a reason not to put a beach access in. It's unsafe. We don't want people throwing trash. We don't want people coming down by our house. There's always some reason why somebody doesn't want it. But this location, you've got the right-of-way, and you've got the right-of-way to make it safe. All you do is make it into a T intersection with stop signs on both ends. So I think with engineering, you can do almost anything. I think the idea that you can't make this safe is really kind of not a really good argument in my mind. So I think that I just don't want to be the board that starts blocking off these public accesses. Make them safe. Design them so that they are safe. You can do that. We have engineers that design bridges that are safe. So design it. Make it safe. Make it a nice little place for people to pull their bikes in and walk down. And, there's thousands of cars down there, thousands of people on bikes, thousands of strollers, thousands everywhere, all up and down 30A. And so, it's really not a reason to not add a walkway.
I have, what?
I need to ask counsel something.
Oh, sure.
Mr. Davis, I'm looking at one of the documents that was presented to us showing it purports to be some type of survey, et cetera. I don't know if y'all got it, where it's the one that's got the yellow highlights on it.
Yeah, the one that shows
It shows that that beach access that walkway that's come in from the private residence onto what is identified as a 20-foot plat. Yeah, there it is.
That's it.
Now, I think there's been some testimony concerning that it was approved by the county and also DEP to put that particular walkway there.
Commissioner, we probably need to get somebody from Public Works. I know that the Public Works did do a survey and found within the road this particular overwalk. I have no idea. I just don't know if it was permitted by us or not. Let me say, I want to make sure we're clear about something. You cannot under any circumstances adversely possess property and gain title against a county. You can put something right away, and our acquiescence to that does not give them. I can adversely possess against an individual, but you cannot adversely possess against the county. So if it's there and we know about it, that doesn't mean that they gain any greater rights to the property. I just want to make sure
I know,
that's
but what happens
legally
is,
clear.
I know, but what happens is the next person they sell to, they sell a deed that says they own part of that, and it gets transferred. And then you got somebody who buys it and says, "Oh no, I own this. I own this." Then you got to fight them in court.
Right,
and that's what we're looking at on a lot of these things.
Yeah, it doesn't mean they won't try, but there is legally the idea of adversely possessing leading to title.
Well,
doesn't really exist.
getting back to what I was going to ask you, Counsel, that structure that's out there in that recorded plat is sitting inside that 20-foot.
Yes, sir, it is, as I understand.
Now, if we take the position that any obstruction that's within these county right-of-ways, then that is to be moved to the east, off that.
We would certainly have the authority to require that.
Because if at some point in time, if there's an access put there, you're not going to be able to put it in that 20-foot.
Correct.
If somebody had an accident on that walkway there, what would happen? Who would be liable?
That's a great question.
And that's one of my points. Is
the answer would probably be we would probably be on the hook if we were aware of it and if we permitted it. Yes, ma'am.
Yeah, that would be my thought on it. And if we own the bluff, they could always get an agreement with the county that they could leave it there. I mean, I just said that they either needed to remove stuff out of county property or get a right-of-way agreement.
But if they gave the agreement to leave it there, then I would think it would come with a parameter that the people could use it. And if it anchors on private property, I don't think they're going to be willing to do that unless there's some type
Well, no, there's definitely an issue there because it is in the place that you would have a walkover.
I'd like to make a motion, I think, that we still have some unanswered questions, and although I say I'd love to settle this tonight, we have some public works questions, we have some safety questions, we have that sort of thing. Can we defer this and give Public Works a chance to meet with each one of us individually, or at the next meeting to tell us, if there's if a road can be put there, or straightened out or whatever, can it be done? If not, if we can't do it, then I would ask the attorney, do we look at selling that? If we can't, then do we look at selling it to the people that are next to it? I mean, we're selling, but I'd like to hear from...
Selling beachfront access to people?
Let me
I
finish,
can't
please.
believe my ears.
Let me finish. I've listened to, I would like to hear from Public Works on the safety issue, and did we authorize that there or not? I haven't seen any paperwork saying that we did. I would like to hear about all that before I make a decision, and that's my motion.
Okay, we have a motion. Do we have a second?
What was your motion? Like, and succinctly, to just continue it,
To hear
continue
from
this?
Public Works, yes, and to see the safety issue.
To get more information?
To get more information. Did we authorize that walkover, or did we not? Did DEP,
Well, even if we, let's, okay, well.
Anyway, that is my motion. Okay.
We have a motion. Do we have a second? To allow Commissioner Commander more time to talk to Public Works to get more information.
And all of us, not just me.
Well,
Yeah.
Well, two of us are not going to be here, and maybe three of us. We don't know. We'll get the results tomorrow. So there may not be. We won't be here to talk about it. So I do agree, though, that you may need some more information.
I'll second it.
Okay.
But I do think it's worth looking at in the idea of selling land to beach access land to private owners. Boy, that's really going out there.
I call the question.
Okay, we have a motion and a second.
Oh, did you want to say something, sir?
Well, I was going to express a concern that I've had all along, even though we're going to vote on this, and that I've worked with Mr. Toosa and Mr. Kellenberger, and I know that the cost data that I was given back in April, which was the basis for my rejection at that time, it hasn't changed. I know it's in template form, but I would ask, because the concern was vis-a-vis the other accesses, that they at least take that time. So whether it's me before the next meeting or my successor, that they round that out as part of your rounding it out with Public Works so that it can all come back in one package.
Exactly.
Thank you.
I will agree.
Not the individual meeting with me, no ma'am.
No, I actually asked them to bring me back a comprehensive plan and show me where there was places that we did not have an access. And I haven't seen that yet. So anyway, we have a motion and a second. Any other comments from the board?
Questions already been called.
Okay, the question's been called. All in favor, say aye. Aye.
Nay, I think you ought to go ahead and make it a public access, but, you know.
Mr. Empfeld.
Madam Chair, thank you. And again, my heartfelt thanks to the citizens of Walton County for allowing me the privilege to serve them for the past 4 years. And I wish Godspeed to all the people still here and the people that have been here to enjoy the meetings over the past 4 years. And special thanks to my fellow board members for helping to keep this process going in a positive direction. Thank you all.
Certainly. Yeah. Commissioner Jones.
Just happy Veterans Day and be in prayer for the election tomorrow.
Isn't that the truth? Commissioner Chapman.
The only thing I have is I want to thank Ms. Cindy and Bill. We didn't always agree on everything, but I think we did move forward over the last 4 years.
We did a lot, yeah.
Got a lot accomplished, a lot of good was made, and I want to thank you for being there and working.
And Bill, thanks for the new vocabulary that I've learned, many new words that I didn't know before.
Did you get them all in the book?
Thank you. Yeah, they're all in the book.
Good.
You will be getting a copy of it. You will be getting a copy of it.
Okay. Thank you all.
All right, I actually have nothing. I do have a citizen's request from Ross, and I'm not going to say that, but I'll let you do it.
It's Ross Weinschenker, Weinshenker. Madam Chair, Vice Chair, Commissioners, and the rest of Walton County that's here tonight, thank you for giving me the time to present this. I hope it's a far less contentious issue than the last one. It's small, but it's small potatoes, but it's big to me. Currently, we have an issue where my property, as you can see up on the screen here, the county road, which is Sally Lane that runs east-west, and then Turquoise Beach Drive, which is north-south, doesn't provide adequate access for property owners, emergency services, or county services to parcels in the immediate vicinity of my property, which is the one outlined in red. South Walton County doesn't currently maintain Turquoise Beach Drive past where the white stops right there. It leaves 4 parcels without adequate residential access. Lack of access has created significant safety and administrative issues as myself and my family utilize this every day as our only means of access to our property. Regular 2-wheel drive cars really can't access this well at all because it's about 8-inch deep sand, which I'll show you in some further photos. I've had to tow my wife out over a dozen times, and I've gotten stuck twice in my truck, so it is an issue for us. The reason why we're asking for this now is because when we purchased the home in 2014, we used to access, it's actually what a lot of people have been talking about tonight, it used to be a county right-of-way on the north side called Ann's Lane. After we closed on the property, that's where the old driveway was. The gentleman who owns that closed us off and blocked us in. So after about a year legal battle, we purchased the driveway to the south, and now we have access to the county land, but it's not currently a maintained road, which causes some serious access issues for us. In the last 2 years, we've had a flatbed semi get stuck. The UPS truck's gotten stuck 3 times, and they won't even go down the road anymore. The mail truck gets stuck about once a week, and the trash truck once about 3 months ago, and we had a fire issue we called the fire department. They couldn't get anywhere close to our property, and I had to walk them in from 2 blocks north of us. So it's an issue that we have. School buses can't get in, and basically we have no access to our property unless you have a 4-wheel drive car. I pay $4,200 in taxes, which seems very small probably to this crowd, but for the taxes that I pay being a landowner here, I don't think I'm getting the services that I'm paying for out of the land that we own here. That being said, I think you guys should have in front of you an area overview which kind of shows what we're asking for. There's currently a county easement, which is about 5 different parcels. It's the one south of Turquoise Beach Drive there, and then the 5 above that as well. It's currently a 66-foot wide easement. It's about 200 feet long. What we're asking for is the maintenance of about a 200 by 30-foot section that would provide us a county road down to where the entrance to our driveway currently is. And if you've seen the photos in front of you at the packet I provided, you can see it's fairly difficult to access. After doing the investigation on this, there's a couple options that you are welcome to explore, just what we've looked into. Option one is that the county would maintain the current ownership of the property. They would just maintain the road down to our property. The cost to improve this, to make it a county road, we did the investigation in this. It was about $1,000 in materials, and pay to grade for Walton County is $25. So we're looking at about $1,000 investment, and then a $300 annual maintenance fee that, from what we could see, to maintain this. The other option is that we would take ownership of it and maintain it ourselves. I think that involves a lot more legal issues that we'd have to get into, putting it up for bidding and so forth. So all we're asking is that the county would maintain this road down to our driveway. Whatever you choose to go with, I appreciate your time in hearing it, but that's all I have.
Ross, if I may, Madam Chair,
Yes, sir.
you purchased this for taxes not being paid, correct?
No, we purchased it to live in. The taxes,
Right, I understand that, but how'd you get the property? From a tax sale?
It was from a auction, foreclosure auction, yes.
Okay. So I'm making an assumption that you looked out there and drove out there before you purchased it. So,
Absolutely, sir.
so you knew what type of road you had coming in there and that it wasn't county maintained?
Yes, sir. And to clarify, sir, if you look where the white road, Turquoise Beach, comes down, that actually intersects with the old driveway, sir. And when we purchased it, we had access along the old driveway. After we closed, we think it's probably due to the fact that the landowner that owned that didn't like the fact that we won the auction and put up 2 fences and blocked us out. For almost a year, we couldn't access our house. So we finally were able to purchase it from him for $25,000.
Okay, where the white stuff stops, I'm going to make it assume that's to the east?
That is to the west, sir.
Okay, to the west. Right there, Rick,
Yes.
where you got your cursor. All right, the county maintains from that point back up to the other road?
They actually only maintain to the intersection of Sally and Turquoise, but enough people drive down that white portion that, I mean, we don't necessarily need it, but the 200 feet covers from Sally Lane to our driveway,
All
sir.
right, but when you were using the old driveway?
Yes, sir.
And you went there, he fenced you off or whatever, did you put it in from the end of where the cursive is back around to your property line then?
We didn't put anything in there, sir. It just, we were able, if you see the red stretch, that little cleared area, we cleared to the county land.
So
Yes, that.
Where's the county own? Right
They
there?
own that
Right
parcel
there?
right there, sir, yes.
Can we ask Public Works to take a look at this? Because I don't think it's going to be
That's what I was
decided
gonna
tonight.
suggest.
That's
But,
county policy has been to have them go ahead and assess it. I would
Yes.
recommend that we go ahead
Yeah.
and have Public Works take a look at it.
Yeah.
yeah,
And bring back an assessment
yeah.
to the
I
next
agree.
board.
That would be, if I can direct staff to do so, Mr.
Yes,
Jones.
ma'am. Be glad
All right,
to.
We will. We will have direct staff to look at it, brings back a recommendation, and they will let Mr. I see Buddy's head peeking around the corner. If you'll be sure, I don't know if you have his phone number or what, Buddy, if you get it so that you can communicate with him when we're going to discuss it again. Thank you. You get with Buddy.
Yes, ma'am.
Thank
Thank
you
you.
so much.
Appreciate it.
All right, at this time, I have other public comment, if there's anyone. I was on a roll. At this time, we have other public comment, if anyone would like to comment at this time. Mr. Hudson.
Now she forgot what she was saying.
Miss me.
We didn't know the log for the fire. It's been very cold in here tonight to me, but my name is Bob Hudson, Hudson, and I'm wearing a little bit different hat than when I spoke before. I'm wearing the hat as the Executive Director of the Walton County Taxpayers Association, representing our president, Zuma Banks, who was unable to be here tonight. You know, I'm celebrating an anniversary because 15 years ago I came to the first Board of County Commissioners meeting I've ever come to. And so it's a special night for me as well.
We'd have known we'd had you a cake, Bob.
Happy anniversary.
Or a ding dong.
Or a ding dong. yeah.
But I am here tonight representing the Taxpayers Association and wanted to express our appreciation to two individuals that I've had the pleasure of working with on more than one occasion. You know, this country is divided. I don't know what the outcome of the elections are going to be tomorrow, But I just hope this country can move forward, just like I hope this county will move forward under whoever the new commissioners end up being. You know, we're all assuming certain things are going to happen, but you never know what's going to be there. But Cindy, it's been a great pleasure to work with you. You've been a person that takes phone calls from us when we have questions, and you listen to us at times, and at times you don't listen to us, and that's perfectly normal. And Bill, the same thing is true with you. I've only had the opportunity of working with you as a commissioner for 4 years, but had a long opportunity of working with you in your previous one. Look forward to having opportunity of working with you in your new position as the Economic Development Alliance Director.
Thank you.
And Cindy said she was going to take on the role of private citizen, and I understand that. I've been able to do that for a while. But on behalf of the taxpayers, you know, everybody says, well, they get paid. And I understand, you do get paid. I've served, I've been there, but nobody pays you for what you do. I can assure you. And I've seen you try and divide the baby on more than one time, and that's difficult to do. But I express my appreciation to you, and everybody in this county should. Nobody ever does what everybody wants them to do. Sometimes I don't even do what I want to do, if you understand what I'm saying. So my dad told me one time when I was asked to serve and ran for the school board in Dothan, Alabama, he said, son, remember 3 things. And I said, what's that? He says, you're never going to make the right decision no matter what. 50% of the people are going to agree with you and 50% are going to disagree with you. Second thing he said was, he says, never hire an expert, because when you walk out of the meeting, there's one on every corner. They know the law, they know everything, the land development code or whatever it happens to be. And the third thing is never forget why you're there. And in that case, it was for the kids that I was helping through education. And Mark, thank you for your service too, by the way. I saw a little video of your moment in the camera lens, I'll say. But mine was at that point in time serving kids, and your job has been representing the people of Walton County, and I think you've done an outstanding job of doing that. And yes, you have made a lot of progress for the last 3 years. Look forward to working with everybody in the future. Thank you.
Thanks,
Throw a
Bob.
log on the fire.
Thanks, Bob, and thanks for keeping, you know, your role and the taxpayer's role, critical role, important. That
Y'all
keeps
made my
everything-
job a lot easier the last 4 years.
Well, it keeps everything. It's definitely needed and necessary, and it's a
Well,
lot of
thank you.
work on y'all's part as we thank y'all for that as well.
Well,
'cause-
thank you. Look forward to
Thank you.
working with everybody in the future.
Thank you, Mr. Bob. Is there anyone else? See,
If I could just take a moment to
Yes.
say to the Commissioner Enfield Meadows, thank you for the opportunity you've given me to serve in this capacity. It's been unique in that served with Commissioner Meadows 4 years on the board, and Commissioner Enfield worked closely with us in finance during all that time. So I feel like I've just worked with family through this over the past 3 years in this capacity. But I want to tell you personally, I appreciate all you've done to help me along, the opportunity you've allowed me, and from a staff position, the support that you've given us as we've brought things to you that needed your vote and your attention, and we just appreciate it and want to say thank you.
Thank you.
And staff, thank you, staff. You can't name all the staff, but legal department has just done a yeoman's job, in my opinion, bringing us to where we are today, where people think twice about suing us now, you know? Yeah, people think twice about suing us now. And the staff and everything y'all have done, how far y'all have brought the county and TDC and planning and just, you know, it's a great group. It's a great group. And I enjoyed it.
I'd like to just echo, staff is what made everyone successful. It's not us individually, it's not you individually, but it's you and all of the staff, TDC, planning, public works, finance, everything. So again, it's the hard work of all your employees that made this possible.
Yeah, I agree. Ditto.
I want to echo exactly what Larry said, and thank y'all for allowing me to grow into this. I'll be honest with you. When I got that phone call in January of 12 or 13 saying, can you cover a meeting? I had no idea what I was getting. But you guys were very patient and let me grow into it. And I deeply appreciate your patience. I really do.
I want you to know what you were getting into. We were
Cover
afraid
that turned into a lot of work.
Yeah, can we sing Kumbaya?
Something
Shall we
keep
sing
quiet.
We Are the World? No.
Well, if y'all are ready to continue, then
Thank y'all.
Mr. Dice is not here tonight, so I will defer to Mr. Carpenter.
Thank you, Madam Chairman. Matt Carpenter for the Planning Department. On our list of items for the planning section, we've already dispensed with item number 1 at our 2:30 meeting. Item number 2, this is a request to approve by final order the YOLO Board Distribution Center. This project is being reviewed by Rita Banhanyati.
I need to swear everybody in. Anyone who anticipates speaking
Counselor.
on any item on the quasi-judicial docket before this board, would you please stand and raise your right hand? Do each of you solemnly swear or affirm the testimony you're about to give to this board will be the truth? And if you would, say your name and spell your last name for the board.
Before you do that, do you want to do the resignation of David Smith?
Oh, I'm sorry, we missed that.
You didn't swear anybody on the 2:30 meeting.
Didn't have to.
It's QJ.
Nobody
It was a
spoke?
motion to continue. We're good.
Be quiet over there, please.
Yes, ma'am.
Mr. Carpenter, yes.
Before we move into the quasi-judicial, we do have a resignation letter from a member of our Planning Commission, Mr. David Smith, for the board's consideration.
Do we have a motion to accept the resignation? So moved.
I'd like to comment, he is honoring the fact that you have a new commissioner coming into District 3, and he wants to allow that commissioner to have their representative on the planning commission.
Very good. We have a motion and a second. Any further discussion? Seeing none, all those in favor? Aye. Motion carries. Now then,
Thank you.
QJI items.
And now, Rita Banner.
Good evening, Rita Banhunyadi from the Planning Department. The YOLO Board Distribution Center, this is a major development order application submitted by Emerald Coast Associates requesting to approve a 14,065 square foot of distribution building on a 0.9 acre lot with the future land use of village mixed use. This parcel is located northwest corner of intersection 98 and Veterans Road. Previously, the Technical Review Committee recommended for approval this project, also the DRB and the Planning Commission. We have no public comments. All department comments were addressed. There's an outstanding proportionate fair share amount of $75,480. There's a condition in the final development order. That would be it. If you have any questions, I would be happy to answer.
Do we have any questions, ladies and gentlemen? Anyone in the audience like to speak to this issue? Seeing none?
Motion to approve.
Second.
With conditions.
With conditions.
We have a motion and a second to approve with conditions. All those in favor?
Aye.
Motion carries.
Thank you, Commissioners. Item number 3 is a request to approve by final Mylar the Prominence Phase 3 North Plat, and this one was reviewed by Renee Bradley, and she'll present this project.
Good evening, Renee Bradley, Walton County Planning Department. This is a plat application submitted by Interlight Engineering requesting approval to plat 25 triplex buildings consisting of 75 units. The project consists of 6 acres with a future land use of traditional neighborhood development and is located north of County Road 38 within the Prominence Plan Unit Development and Development of Regional Impact. All technical comments on this project have been met. All fees have been paid. In your staff report, we were lacking at the time the recreational fee and the 911 addressing. I do have the receipt and checks for those. They have also been paid. So the only fees that are due at this time will be the recording fees of the final plat. We do not have any outstanding technical review comments and no public comment. I'll be glad to answer any questions for the board.
How much were the recreational plat fees?
The recreational plat fees, ma'am, was $124,651.28.
It's not District 2, but.
Makes you want to cry. Any other questions from the board? Anyone in the audience like to address this issue in any way? Seeing none, your pleasure.
Motion to approve.
We have a motion to approve.
Second, providing the motion has includes conditions of
With the
approval.
My
conditions.
motion includes conditions.
Her motion does include conditions. We have a motion and second.
Second.
All those in favor? Aye. Motion carries. Thank you, ladies and gentlemen. Good evening.
Motion to adjourn.
Bill wants to sing "We Are the World."